list old matter. Item number 1.
Delay is how much, sir?
But this has become infructuous.
All right. Counsel, the appellant states that the appeal has become infructuous. It is disposed of.
Supplementary old matter. Item number 2.
Number 2, my lord, not pressed, my lord, infructuous.
Not pressed, it's disposed of.
Obliged.
Supplementary list. Item number 3.
The matter has become infructuous, man.
All right. It's infructuous, disposed of.
Supplementary list. Item number 4.
None appears disposed of.
Supplementary list. Item number 5.
My lord, item number 5 and 6 both are similar to item number 1 of the yesterday supplementary list, where my lord are directed to dispose of the appeal case which is pending before the respondent number 1, member board of revenue.
All right.
Yes.
Same order as yesterday's item 1. All right.
5 and 6.
My lord, maybe disposed of.
Disposed of. All right.
Supplementary list. Item number 7.
My lord, the matter has become infructuous.
All right. Infructuous, disposed of.
Supplementary list. Item number 8.
Item number 8, my lord. This is matter. I'm appearing on behalf of the appellant, my lord. Matter, in the meantime, there is a judgment of the Honorable Apex Court which covers this case, my lord. This is regarding the imparting of BR architecture courses in the university, my lord.
Yes, tell us.
Lordship, may kindly have a glance at page 32 of the judgment, my lord.
No. First, tell us what the issue here is.
Issue is, my lord, Shiksha Anusandhan, a deemed university, wanted to open. They have advertised. Probably they are no longer imparting BRK education, but for the sake of argument, my lord, they have issued advertisement for admission into BR courses, my lord, in the writ application, pursuant to which Council of Architecture issued 2 letters. They said that is under Annexure 4 and 6. We said that before imparting any education, you need to seek
Prior permission.
my lord, prior approval for imparting education, which they have challenged before this honorable court. And this honorable court, by judgment dated 8/4/2013, the learned single judge held that
They're not required to obtain prior approval.
Prior approval from the AICT as well as Council of Architecture. But 1972, the Architects Act is an act which holds to, because in order to practice architecture, you have to hold a degree which is recognized by the Council of Architecture. Otherwise, you cannot practice architectures in the year. Moreover, the Architecture Act as also
Architects Act.
Architects Act, my lord. Architects Act as well. It also requires that section. They have to maintain minimum standards as well as.
Who's appearing for the respondent?
Probably no one is appearing because they are no longer.
Millers, I am appearing for the respondent number 2 AICT.
So you agree this is covered now?
Now this is covered by the Apex Court judgment
All right.
in 2019 volume
Correct,
16.
Correct.
Yes.
Counsel for both the appellant as well as opposite respondent number 2 agree that the impugned judgment of the single judge request to be set aside in view of the judgment of the Supreme Court in All India Council for Technical Education, which is Sri Prince Shivaji Maratha Boarding House College of Architecture. This will have a Manu SC 15342019. There, the Supreme Court has made it mandatory for a college seeking to impart a course, offer a course in architecture to seek the prior approval of the Council of Architecture. Consequently, you say, consequently, the impugned judgment of the learned single judge is hereby set aside. The writ appeal is allowed as breakthrough.
I beg pardon to mention in the middle, my lord, item 4, my lord. At the time of call, I could not reach, my lord. I was held up in another court, my lord.
Carry on.
Yes, my lord.
This item 8, my appearance may be noted.
All right.
Obliged.
In item 4, my lord, we have challenged the order of the Honorable Single Judge, my lord, which is at page 17, my lord, wherein the Honorable Single Judge has allowed the petition of the respondent number 5, which is a private respondent, and directing that private respondent to be engaged as a Anganwadi helper, which the relevant, the order starts at page 19, my lord. The relevant portion is at page 20, my lord. Considering the rival submissions of the parties and after going through the record, it appears that there was no provision to file appeal so far as selection of Anganwadi helper is concerned as per the government guideline issued on 24/11/1997. Therefore, appeal filed by the opposite party number 5 before the sub-collector. Opposite party number 5 is the present appellant, my lord. Before the sub-collector, Puri, is not maintainable. Accordingly, this court quashes the order dated 30/10/2010 passed by the opposite party number 3, sub-collector Sadar, Puri, in Anganwadi miscase appeal number 21 of 2010. Full stop. However, it is open for the opposite party number 5 in case she is agreed with the selection of the Anganwadi helper. She may apply before the appropriate forum. Here, my lord, the guideline which the Honorable Single Judge has relied upon, that is at page 12, my lord. The guidelines only speak about the selection process of the Anganwadi helper, my lord. And that selection process was also not followed by the appointing authority while appointing the respondent number 5. On that ground, the appellant has approached before this honorable court in the previous writ, and the honorable court in the previous writ of 2010 directed the present appellant to prefer an appeal. Pursuant to that direction, the present appellant preferred an appeal, which is at page 13, my lord. The relevant portion it has page 14, my lord. In that appeal, the respondent number 5 also entered her appearance, and it was heard in presence of both the parties, my lord. Page 14, my lord, the relevant portion.
Yes.
The last paragraph. Had the learned advocate for the appellant and respondent gone through the report submitted by the CDPO, Nimapara, regarding selection of Anganwadi helper in respect of Kodalibari AW Center, full stop. The CDPO has submitted that due to heavy pressure of work, all members could not attend the Mahila Sabha meeting. Therefore, she finalized the candidature in a separate meeting at block headquarters. In respect of Kodalibari AW Center, the meeting was conducted by the lady supervisor. The next part is important, my lord. Neither the CDPO nor the ANM have attended the meeting. The guideline says that the selection should be made in presence of the CDPO of the project, who is the chairperson, the supervisor in charge of the area, who is the member, and the NM in charge of the area, who is also a member. In the presence of these 3 persons, the selection has to be made. Here the finding is that only the supervisor was present, neither the CDPO or the NM was present. On that ground itself, the appeal was allowed in my favor, my lord.
But was the appeal maintainable is the question. Because I think what the single judge holds is that the appeal is not maintainable before the sub-collector.
The Honorable Single Judge relied on that guideline. The guidelines only prescribes about the selection process, how the selection is to be made.
Why has the writ petition been allowed? See that.
May I kindly have a page 20, my lord. Considering the rival submissions of the parties and after going through the record, it appears that there was no appeal provision to file appeal so far as the selection of Anganwadi helpers is concerned as per the government guideline issued on 24/11/1997, which is at annexed at page 12, my lord. that page 12, thus may kindly have a glance at page 12, my lord, annexure 2.
Yes.
The subject matter of that circular is guidelines for selection of helpers for Anganwadi work centers. That is only the circular, my lord. How the Anganwadi helpers will be selected.
No, but where do you get the provision for an appeal before a sub-collector? Where is that? Where do you find it? You can't simply invoke a remedy which does not exist, right? If you're aggrieved by the appointment of the opposite party, number 5, is it? As Anganwadi worker. Whose appointment were you challenging?
Respondent number 5.
Where do you get this that you can go to the sub-collector?
Well, it's the 1997 rules guidelines admittedly doesn't have the provision. And my lords, I'll just have to come back to my lords. The later guideline, my lords, has an appeal provision because the appeal first lies to the sub-collector, thereafter, my lords, to the collector. So there is a provision, but my lords,
Are you aware of any such provision?
There is no provision, but there is guidelines that there's circular that the appeal will lie to the sub-collector.
Where is that? Please, you'll have to show us something.
my lords,
Where do you get
just
it?
one factual argument submission, my lords. My lords, at the time of filing the writ petition, my lords, the age of the present appellant was 35, my lords. That
Yeah, now she'll be 42.
no, my lords,
44.
my lords, actually, there's a discrepancy, which is why, my lords, the impugned order, my lords, if sees page 18, the impugned order is that writ petition was filed, my lords, 2010. Obviously, my lords, the present appellant was respondent, but the
34
age
years.
is showing 34 years at 2010. So by
Now
now,
she'll be 46.
46. So
What is the upper age
the
limit?
upper age is 44.
So
There is a stay order operating, my lord.
So what? The upper age limit is crossed. You can't, when a stay order will not prevent, stay does not prevent the aging.
My lord, the appellate authority have found that the selection process by which
This is why
the
you need to
respondent number
mention the
5
matter. You have to get it for early listing. You have to tell the court somebody's, the appeal is getting infructuous because she's crossed the age. If you keep quiet like this and wait for it to be listed on its own turn, this is what will happen. It will all become infructuous. You say with the age of the present appellant being shown as 34 years at the time of the writ petition before the learned single judge, filed by the opposite party number 5 in 2010. At present, the appellant would be more than nearly 46 years old. Full stop. The upper age limit for an Anganwadi worker is 44 years. Full stop. On that short ground, the appeal has been rendered infructuous. It is disposed of as such. The question of law is left open for the decision in some other case.
Great. Supplementary list item number 9.
None appeals.
Item 9, all the three matter, my lord, became infructuous.
All right.
No instruction.
9, 10, and 9, and yeah, all 3 appeals. Right.
3 in the 9.
Right.
Supplementary list item number 10.
Item number 10, my lord, the delay of 500 feet.
The delay of 500 days is not properly explained. Consequently, the delay is not condoned. As a result, the appeal is dismissed.
Supplementary list item 11.
Item 11, your lordship, no instructions, because in the meantime, most of the petitioners have died, your lordship.
All right. No instructions dismissed.
Supplementary list item number 12.
Item 12, my lord, no instruction.
No instruction dismissed.
Supplementary list item number 13.
13 may I please? I mean virtual move, my chief. See, in that case, the present petition challenging the illegal and arbitrary action of the opposite petitioner not giving benefit under agricultural insurance scheme, my lord. That is implemented during the Kharif 2013 crop paddy crops, my lord. The present petition is the president of the Krishak Vikas Mancha of Balrampur GP, my lord. My prayer before my lordship, that was in page 11, my lordship has given my prayer, my lordship. the present of the farmers are there is a general body meeting also was taken place among the farmers, my lords. Under annexure 1 and 2, the farmers of Balrampur Gram Panchayat are eligible to take the benefit of GP, my lords, the crop insurance scheme, my lord. Under crop insurance scheme. They are suffer a loss, my lordship.
Was notice issued in this?
Notice has been issued, my lordship.
Way back in 2014, sir. There's a counter
Yes,
affidavit filed.
yes,
What does
my
it say?
Counter filed by opposite party 2 and 3. Well, this is for the Kharif 2013 crop season.
So I don't know how we can now order anything at all, sir, at this distance in time. There are representations, right?
Well, representation is also there, my lordship. Representation is annexure 5 series, my lordship.
But there's nothing to.
Counter has been given, my lordship. The counter has affidavit filed on behalf of the opposite not 8, my lordship.
Yes.
Counter has been filed, my lordship.
Yes. What does it say?
He has the deputy general manager of agriculture insurance company. He has admitted that the present petitioner has lost sustained due to some maladies with the crop.
I beg to pardon, your lordship. I may be permitted to satisfy your lordship. The annexure 3, your lordship. In the year of 2013, there was a crop loss, your lordship. A survey has been made by the RI, your lordship, and RI given report, your lordship. So far, Balrampur Gram Panchayat education, there is a crop loss of 75%, your lordship. And save and accept this Balrampur GP, your lordship, under Baliapar block, your lordship. All other block is given compensated on the insurance scheme. And so far, the Balrampur GP has not been given, your lordship. So we obtained the instruction thereafter filed representation. When our representation has not been taken to consideration, we filed the public litigation before the National Court that the farmer loss, your lordship, has to be with a prayer to it has been compensated, your lordship. Now their notices has been issued and the opposite party appeared, your lordship, and a counter has been filed. So far, opinion number 8 is concerned, lordship. And he stated that, your lordship, that the liability is lost to the central government, not liable to support the state is concerned, lordship. And annexure 3, your lordship, is disputing that, your lordship, the RI is not the appropriate person to survey and file report, your lordship. But as per the revenue disaster management, lordship, always it is a principal, lordship, the Tahsildar, who is the immediate revenue authority. He has to make the investigation and submit the report before the authority, then authority will also make compensation, lordship. Accordingly, RI has lordship submitted report, that is annexure 3, lordship. And indication given 75% loss, lordship. As per act and guideline, we have to compensate, lordship. That has not been compensated, lordship.
Can I ask you a question, sir?
Yes, my lord.
This is a crop loss of which year?
2013, your lordship.
And we are in which year now, sir?
This is year also 2021, your lordship.
21?
22 years. Sorry, 22 years, lordship.
So how many years have gone by, sir? How many years have gone by?
Lordship, by the process, the opposite party has taken so many time, lordship, have a glance the repetition, lordship, they have not been.
No, after 9 years, 9 years, is it practical to order inquiry into crop loss after 9 years?
The report is there, your lordship. Their factual background report is there already. We submitted the report annexure 3, your lordship. This is the RI report. It's an appropriate authority by the government. Annexure 3 page submit very clear so far as the page, your lordship, concern. Annexure 3 page 19, your lordship. The RI submitted the loss is 75% so far Balrampur GP and other Gram Panchayat under Baliapur block, your lordship. This is the report, your lordship.
Come to para 11. of the counter affidavit filed by opposite party number 8?
Yes, my lord. They are disputing the report of so far as the RI is concerned, lordship. A farmer,
Why don't you read it, sir? Why don't you read the paragraph?
that it is respectively submitted that during the year in question, particular case as per the scheme provision for MNS Kharif 2013 season, the actual oil for paddy crop for Balarampur GPO Balapur block of Balapur district was reported as 3745 kilogram per hectare, whereas the threshold wild was 1300 kilogram. Has actual yield was more than the Tahsildar yield, more than the threshold yield. Therefore, no shortfall in the yield. Hence, no claim was paid for the GP under MNS Kharif 2013 season for the paddy. Your lordship, where from this report, your lordship, unless until the actual report has been collected immediately.
These are all highly disputed questions, which is why I'm saying we cannot simply accept whatever you're saying at face value. They are disputing, they're saying their actual yield was more than the threshold yield.
Yes,
there was no crop loss. The whole petition is based on crop loss, correct?
Yes, my lord.
This shows that your yield was much more than the threshold yield, sir.
That is not actually reported. The actual report, your lordship, be taken to consideration so far the RI report is concerned. Then that is disputing so far the page 11 has been counter given, lordship. And they have not been survey, lordship. The survey has been made by the RI, lordship. As per the survey, RI submitted report, your lordship. And they have not been practically made field verification, lordship.
So they've also enclosed annexure B8.
Yes, my lord, that is
it
there.
It shows the yield data. So it is based on data, sir.
Their data, your lordship, they have been made in their official lordship. They could have been taken into consideration.
No.
That the data has not been disclosing that they have been gone to the report of the RI, your lordship.
No. In fact, in your rejoinder, you simply said it's a matter of record. You're not able to counter this. In your rejoinder affidavit, para 9, you've clubbed all the paras of the counter affidavit and said these are matters of record. You have not disputed the yield figures given in para 11.
The report they have been submitted, their report, your lordship.
No. You have nothing to show contrary to that, sir. In your rejoinder, you simply say it's all a matter of record.
They are the farmers, your lordship. They are simply ensure their crop, your lordship. Save and accept they do not have anything, your lordship. The farmer is very poor and they also do not know about the procedure.
This is the only argument is this, sir, in every matter. The minute we ask you about some facts, we ask you about law. The standard response is farmers are very poor.
No, it's a farmer's issue, lordship. It is just a normal phenomenon, lordship. They after.
Sir, everything has to be based on some fact, correct?
This fact, lordship, my respect to submit the account. They have been given so far the IL data is concerned. That IL data is not in accordance with the RI report, your lordship.
You can't simply say that, sir. You have to show, that's why you file a rejoinder. In your rejoinder, you have to say why that report is incorrect. Why that yield data is incorrect.
Can I permit you to more one?
No, sir. This is already 9 years old. This is what I kept telling you. Already a stale matter. We're trying to breathe some life into it, but you are not ready.
One day tell us mechanic fix because there is a
sorry, sir. That we are not doing. No, certainly we are not adjourning it, sir. Sorry.
Yeah, lordship, the area is now under flood affected, lordship. So far, the present scenario is concerned.
All right.
They are unable to contact and they are unable to give an information, lordship.
All right.
Thereby, so far the IL data is concerned, I could not able to satisfy, lordship.
All right.
Now our preparation is also pending before that, lordship. If your lordship direction can be given so far the made end over so far the consideration of the said reputation and accordance with.
No, that will not serve any purpose. Now, after 9 years, it will not serve any purpose. You see, the prayer in the present petition is for the farmers in Balarampur Gram Panchayat, bracket GP, in Bargarh district, is it?
No, it's a Balasore district, your lordship.
In Baleshwar district, Acha, to be given benefit of crop insurance scheme vis-a-vis the loss of crops in the Kharif season 2013. In terms of the prevailing government guidelines, paragraph. In response to the petition, 2 separate counterfeits have been filed. One on behalf of the
My lord, I'm opposite party 8, my lord.
Yeah. By the Deputy Director, bracket P and S, DPMU Baleshwar, and the other by the Agriculture Insurance Company of India Limited.
Yeah, filed counter, my lord.
Bracket opposite party number 8. Bracket. Full stop. In the counter affidavit of opposite party number 8, it is specifically stated in para 11 as under, take from para 11, whole para 11, page 52. Paragraph. 2 rejoinder affidavits have been filed by the petitioner to the above counter affidavit. Full stop. In neither of the rejoinder affidavits has the petitioner been able to overcome the factual position as depicted in para 11 above, namely that the actual yield was 3745 kilograms per hectare, whereas the threshold yield was 1300 kg per hectare for the said Gram Panchayat, said GP. Paragraph. That being the position, there was in fact no shortfall in the yield. Paragraph. But consequently, petitioner sought to question the correctness of the above factual detail by stating that the revenue inspector's report acknowledged crop loss. Paragraph. It is seen that the above averment in para 11 of the counter affidavit filed by opposite party number 8 is based on open quotation record showing the yield data as prepared, unquote, and a copy thereof has also been enclosed with annexure B by 8. Paragraph. Since there is no contradiction of the above averment by the petitioner in the 2 rejoinder affidavits filed, the court is inclined to accept what is stated in para 11 of the counter affidavit of the opposite party, number 8, to be the correct factual position. Full stop. Paragraph. The petitioner then stated that the petitioners may be allowed to make a representation to the opposite parties for disbursal of the crop insurance benefit. With the petition being more than 9 years old, no purpose will be served in permitting a fresh representation in the matter. Full stop. Since the factual basis has not been established, it is not possible for the court to grant the release rate for the present petition. The petition is accordingly dismissed.
Supplementary list item number 14. Item 14.
Pass over.
Supplementary list item number 15.
Item number 15, my lord, no instruction.
No instructions.
Supplementary list item number 16.
16, my lord, is a PIL. After directions of the Honorable Supreme Court in civil writ petition number 30 of 2014. This is PIL relating to migrant workers.
There's another matter like this we are considering. One Miss Mrinalini Padi. Mrs. Mrinali Party's,
Yes, Maharaj, that was with regard to registration of these migrant workers under the Interstate Migrant Workers Act and social benefits being given to.
This, if my lord wants, it can be tagged, or a brief summary of what this order is of the Supreme Court. This counter affidavit filed by the state at page 4 of that counter affidavit. My lord is looking at page 4. Page 4, paragraph 4 of that counter affidavit.
yes,
So the state government has made a detailed list of steps that it has taken. But then the action plan, my lord will see, filed on 3/1/2020, that pertains to the year 2019-20. So now that is outdated. We are in 2022. So whatever action plan is here, what has been implemented is not here. What we have is only what will be done. So if the state can then file a detailed plan, what has happened in 2022, what they're planning on, and what they've actually undertaken, because my lord will know that until and unless,
then we heard it together.
Mile.
Let's not have separate
Mile.
petitions. The same list along with the petition civil. 15380 of 21 on 16/11/20.
Supplementary list item number 17.
None appears to so
Supplementary list item number 18.
May I please your lordship? Lordship, the matter is infructuous.
All right.
Supplementary list item number 19. Item 19, sir.
19, no issues.
No instructions.
Supplementary list item number 20.
Infructuous.
Supplementary list item number 21.
No instruction.
No instructions.
Supplementary list item number 22. Item 22.
May I please, your lord?
Yes, please.
My lord, this is a PIL, my lord.
Yes.
My lord, the Resident Welfare Association has filed this PIL for objecting the renewal of the liquor license to in a thickly populated area, my lord. Actually, it causes very severe nuisance in the area. So there was an interim order passed in 2020, March 2020, and pursuant to that order, it was relocated. The liquor shop was relocated, but from one corner to another.
I think it has become infructuous.
My lord, on behalf of Mr. Koshi Guru, in item 22, my lord, the shop is closed since long and
closed and new license.
Counsel for the opposite party number 2 states that the shop in question is closed since long. Therefore, the petition has been rendered infructuous and it's disposed of such.
My lord, since it is a PIL, may I seek a direction to the excise department, because the inquiry report, whenever it is filed, though it is a thickly populated area, nearby school and clinics are there, they are renewing license after license in this very particular area. We want to clean. My lord,
Blanket order cannot be passed now. Without any cause of action, he is seeking such a relief.
Yes.
Supplementary item 23.
item 23, my lord, no instructions.
No instructions.
Item number 24.
None appears to
Supplementary list item 25.
May I please, my lords? My lords, this matter is infructuous, so kindly.
All right.
Not
infructuous, disposed of.
Supplementary list item 26.
Published. My lord, 1 week time may be granted. You have not received a counter affidavit till now.
No. What's the matter about?
My lord. It's a PIL. My lord, 1 week time, any day.
to restrain opposite parties from constructing the bridge and village canal embankment. Yes. Was there any interim order?
My lords, may kindly see my counter. In fact, my lords, the construction hadn't started at the time of filing the petition. It was just a permission which was sought by the opposite party against whom the relief has been sought. My lords may see page 2 of my counter. Para 4, my lords.
Yes.
This deponent humbly submits that the opposite party number 3 is running a stone crusher unit in so and so in the district of Ganjam without affecting to the properties of the government, canal embankment and its road. He has applied for a permission for constructing a culvert over the Babandha Potapur canal number 13 to facilitate transportation of collected materials to the crusher site. His application is under process. The deputy executive so and so is now examining the proposal.
This was filed long ago. By now it's all over.
Yes, my lords.
This was filed in 2018.
Yes, my lords. This was at the time of when filed.
Correct. By now it must be all over.
My lords, I'll have to seek.
No, it's all right. You see, the countervative filed on behalf of opposite parties 1 and 2 stated in para 4 as under. Reproduce the whole of para 4. There has been no rejoinder filed to contradict the above arguments. We'll stop in that view of the matter. No further directions are called for at the present petition is disposed of resolution.
Supplementary list item 27.
An issue by the state legal services where fake doctors were found here in Orissa. So there was a crime branch inquiry which was ordered. And then if my lord would see order numbers 4 and 5, they say that action should be taken against the committee members who had appointed him. So after that, I think there's no follow-up action.
I'll seek instructions.
On 24th December 2019, this court noted that it was a serious lapse. No, as the report of the superintendent of the crime branch showed, the selection of opposite party doctors who do not even have BS degree was considered to be, open quotation, a very serious lapse, unquote. The government was directed to take, open quotation, appropriate action against the members of the selection committee, which selected the opposite party's doctors, unquote. Thereafter, the matter has not been listed. Counsel for the state undertakes to file a further affidavit to update the current position in regard to the report of the implementation of the report of the crime branch. List on. The affidavit will be filed at least 1 week in advance with copy to learn senior counsel to be. You're the amicus.
I'm also the counsel for the legal aid. So whatever,
okay.
It's all the same.
To the learned amicus. List on 19th October.
Well,
all right.
Great.
Supplementary list fresh admission item number 28. Item 28.
That appears this was not possible.
Supplementary list item number 29.
None appears this was not possible.
Supplementary list item number 30.
My lord, in this case, I have filed memo, my lord. My lord, the above PIL was filed against an arbitrary demolition of Godagadia Ghat, my lord, just before 2019 Bali Jatra, which was existing in memory of visit of Sri Chaitanya Dev in the year of 1510, my lord, and mismanagement of 2019 Bali Jatra in clearing, restoring roads like Chandin Chowk Balwati Stadium Road, Those are leading to bilateral lack of parking space and
You see,
mismanagement.
there is
And
a
now-
note submitted, all right, sir. There is a note submitted by the petitioner appearing in person, in which it is acknowledged that in this year, there is going to be a revival of the Bali Jatra. Of the Katak Bali Yatra. Full stop. The petitioner states that he may be permitted to represent to the Chief Secretary of Government of Orissa for consideration of his remaining grievances in a time-bound manner.
Within a stipulated time.
When will you make that representation?
My lord, I will make within 2 weeks, within 1 month.
My lord,
The petitioner
representation
make the
for what purpose?
Well, remaining grievance. I have mentioned
Petitioner makes
that
such
now it is
representation regarding remaining
and there is
grievances
a lot of
not later
developments.
than 19 September 2022.
My
It
lord,
shall be
better-
considered in accordance with law.
My lord, better it should be directed to Development Commissioner because he is
And considered by the
additional Chief
Development
Secretary
Commissioner.
from Development Commissioner.
And after hearing the petitioner, appropriate orders should be passed thereon within a period of 3 months thereafter.
My lord, Chief Secretary will dispose of. Or Development Commissioner. because-
Development Commissioner.
Yes, Development Commissioner. He is additional Chief Secretary.
No problem.
All right. The petition is disposed of there.
Supplementary list item 31.
Permitted to withdraw, your lordship.
Permitted to withdraw.
Supplementary list item 32.
32, my lord, yes, it's my lord, PIL case, my lord, against the Kangaroo Court, my lord, most of the villagers suffer Kangaroo Court in Nayagarh district, my lord. They therefore, my lord, petitioner pray before your lordship to take against the opposition number 4 and 5 and ban the Kangaroo Court in village Kalapatna and Kathagada and constitution a peace committee also direct the opposite partner to take a effective step to maintain normally in the village, my lord.
Anyway, all this is not capable of being implemented now, sir.
My lord.
32, right?
Right.
My lord, annexer 5 is pending, my lord, direction to annexer 5, my lord. Initially, my lord, villagers went to the human right, my lord. Human right also passed order, but the opposite power 4 and 5 doing such type of activity. For that reason, more than 20 villagers are familiars left the village, my lord, due to harassment, torture and harassment, my lord.
This representation has been given.
My lord, to the Superintendent of Police, Nayagarh.
Petitioner's representation, bracket annexure 7, bracket, to the opposite parties 2, 4, and 5 shall be examined by the collector or Tahsildar. Collector Nayagarh. And after giving the petitioners a hearing, the reasoned order shall be passed on said representations not later than 14 November 2022 and be communicated to the petitioner within a week thereafter. The court clarifies it has not expressed any view on merits. Petition is disposed of.
Supplementary list item 33.
May I please, Your Lordship? In this case, the petitioner, in this case, or a direction to the opposite parties to make an endeavor to operational of 145 of Aadhaar enrollment center. And I have given the list mail which is not operational. Annexure mail 2, page 22. Total 145 of the mail centers are not operational.
This representation is where? Have you delivered it, sir? Nothing to show this representation has been actually given. What is that to show? Where's the proof of giving the representation?
In this Aadhaar issue, there is dealt with by the UDAI, unique Aadhaar.
Yeah,
This
yeah,
is the
but
organization.
anyway, where is your representation? Where is the proof of submission of representation? It's not there, sir.
He has not given, my lord, the proof.
Permitting the petition to make a fresh representation to the appropriate authorities, and after following up on such representation to seek appropriate remedies in accordance with law, the petition is disposed.
Supplementary list item 34.
Appearance you not even noted.
Yes.
34, my lord, in the earlier read petition, lordship directed the same direction without proof of the representation. Thereafter, he approached the authority, my lord, and
So defects have to be removed. Defects will be removed within a week list thereafter.
Yes. Supplementary list item 35.
obliged.
Pardon to mention 28 to dismiss by default lordship.
Not like this, sir. Call it.
Item 35. 35, sir.
None appears. Who's appearing 35?
Supplementary list item number 35.
My lord,
35.
36.
My lord,
Pass over.
in respect of a private land, he has filed this PIL.
And we'll pass it over.
Okay.
Item number 36.
My lord, the petitioners are the victim of the flood affected area, my lord. They are also the candidate to appear the AS or 18 examination, which has been scheduled to be held on 27/8/2022. My lord, they have filed this writ petition seeking for a direction to extend the exemption to 4/9/2022. As per the circular, my lord, kindly see running page 35, my lord.
Yes.
The OPSC has decided to conduct the rescheduled ASO written examination on 4/9/2022, my lord. My lord, kindly see 35 page, running page 35. Sunday, tentatively. But thereafter, as per the annexure 5, that has been rescheduled before the tentative date, my lord. That is the 27/8/2022.
It's okay, sir. We can't postpone the date and all now.
My lord, they are now within the water logging, my lord, and all the road connection has been.
Sir, not all over Orissa, sir. There may be some pockets in Orissa. Which are those pockets?
They're the affected.
No, we can't blanket. We can't give a blanket order, right? That.
My lord, initially they have fixed tentatively on 4/9/2022. Thereafter, another circular, that is annexure 5, my lord, which is before the date fixed tentatively, my lord.
In fact, on their own, I think they've been postponing some of these exams.
My lord, I pray, my lord, only 4/9/2000 as per
So we can't do it on the first hearing anyway. Without hearing them, how can we just simply postpone the date?
My lord, the law council, my lord, Mr.
Who's the
B.K. Das,
council? Who's the council?
appearing for OPSC, my lord. Normally appearing.
No. I'm appearing with a special counsel. Other ones are there. Mr. P.K. Mahathir is there.
Who's the standing counsel, sir?
Mr. Standing Counsel, Mr. P.K. Mahathir is there. My learned friend is there. I'm appearing as a special
To find out, sir, who's the standing counsel?
The examination matter shifting of a date.
As per their own circular. My lord, initially they have fixed tentatively on 4/9, my lord. Thereafter, my lord, next circular, my lord, answer 5.
It'll be huge inconvenience in one petition for behest of one petition to postpone the exams. How many of them? 9 of them. It's for the authorities to take a call, sir. Can't have a mandamus for that. If you want to make a representation to them.
My
counsel the petitioner seek leave to withdraw the present petition with liberty to make a representation to the concerned authorities for the relief sought in the present petition. The court clarifies it has not expressed any view in the matter.
My lord, Mr. Mahanti, my lord, a train has come.
This post of is withdrawn with liberty is paid for. All right.
Supplementary list item 37.
Oh, I came across
Lord, item 35. Lord, in item 35, Lord, I'm on the way, Lord.
35 is passed over. Item 37.
36. 36.
Item 35, one pass over. I'm on the way, Lord.
36, I think perhaps that in item yes, so recruitment, that is perhaps they have shifted, Lord. Some date.
Anyway, let them make a representations. That's what we remember reading the newspapers that they've shifted. All right.
Supplementary list item number 37.
37, my lord, I am for the respondent, my lord. Lord, you already disposed of, my lord, single matter.
Let me speak.
And one matter, my lord, has gone to Supreme Court, that will also be.
Let me ask, allow me to start my work. Lord, it's an appeal against the order. Lord, you can see page 66. It's the impugned order, my lord. Page 66. What happened? I'm appearing for the State Council for Technical Education and that is an. Let me start so that, my lord, I'm appearing for State Council for Technical Education and Vocational Training. My lord, what happened in this particular case, my lord? This person's, my lord, is a data operator. In fact, the data operator post was not available in that technical education. My lord, what happened in the year 96? We are engaged the 1,000 rupees, my lord, as a contractual basis without in designated post. Without in designated post. Also by heart.
Similar matters we already dismissed, sir.
27 years, my lord, now 27 years.
Please wait. Let me. I think you have a good case. I want to help you.
Have you given them copies of this?
No, I have, because I also earlier lordships dismissed some cases here also, 3 to 4 cases. What happened, my lord? My humble submission before lordship is in 3 folds. What happened, my lord? Here in this particular case, that data operator post was not there also there, my lord. Not at all there. So they have not engaged against any sanction post. Earlier this case which lordship was dismissed in this case, I was also appearing in that cases, my lord. Not that I will go.
No, those were watchman's cases.
Watchman's case. I'm not a stumbling block this case. So what happened? Watchman's case post was there. They are irregularly appointed persons. Here to how it happened, the illegal, because Uma Devi case unruled single judge, but what happened? This unruled single judge said that Uma Devi case is applicable because they're irregularly appointed. My humble submission is that in fact absolutely no post is available. But in that watchman cases the posts are there. This is the only distinguishable in these 2 cases.
How long have they been working?
Yes, I heard your lordships in earlier cases said what is the age? The age is 50, I think. 57. 57. That I understand.
If you also look at the last order of
this case.
No, your statement,
my statement is wrong. If you start, I will start. In fact, the statement is wrong because in my judgment, you see Mr. B.K. Das in page 66. Opposite parties number 2 and 5 submitted that petitioner was initially appointed junior assistant and never junior assistant appointed. His own statement is something else.
Lecture 1 is that appointment letter.
Junior assistant. He is assisting he was engaged to assist. Can't be junior assistant. Annexure 1.
Sir, how long have you been working?
Working in the judgment, it said that more than the considerable length of time, that is appointed regular 24 years more than he said. No,
there's a limit to how long you can
no,
keep
no, my lord,
exploiting.
I am not a person to be the stumbling block. What is not to say isn't PSU. So it is my duty to appraise the entire situation. Not that they
work from people. See, you're taking work for that person for 24 years.
No, because of Lordship, see, what is Uma Devi case? Uma Devi case said that irregular and illegal appointment was distinguished. Then he said that if the intervention of the Honorable Court, is continuing because interim order was there. Anyway, my lord, because 24 years was continuing, and also in some cases, Supreme Court and also confirmed your lordship's order. So only difference is that watcher posts were there, and here the post was not there, not against a sanctioned post, and that is why it's illegal.
So how do you continue then for 24 years without a sanctioned post? How do you keep on taking work from a person?
Lordship, will say how they're because of intervention of the Honorable Court, because interim order
without a post, sir. So the court's intervention comes later.
Yes.
The court writ petition was not filed 24 years ago.
In 13 intervention courts are there. Prior to that, what happened? 1,000 rupees. They have to assist the assistant register and finance. That is why I engage 1,000 rupees. Lordship, what
only after 13 years of work they went to the court.
That is correct, Lordship. But is an illegal appointment. That is my humble submission.
All right.
And without any qualification, that much.
All right. The challenge, the present petition, a present appeal to an order dated 23rd March 2021, passed by the learned single judge in writ petition civil 9437 of 2013, directing the present appellant to consider the case of the opposite parties who've been engaged as junior assistant on a contractual basis for regularization. Paragraph. It must be mentioned at the outset that similar writ appeals filed by this very appellant against certain other individual respondents was allowed by the learned single judge, against which the present appellant filed writ appeal numbers 230, 231, 234, and 235 of 2016. So, the said appeals were dismissed by this court by its order dated 6th December 2021. So, the specially to appeal bracket civil 4893 of 2022 was then filed by the present appellant before the Supreme Court of India, which dismissed those SLPs in limine by an order dated 17 May 2022. So thus the order dated 6/12/21 of this court was affirmed. Paragraph. The only distinction as far as the present case is concerned is that it involves data entry operator, whereas the aforementioned proceedings in which the Supreme Court affirmed the order of this court pertain to watchmen. So there, the watchmen in question were working for
also since 96.
over 10 years. As far as the present case is concerned, the data entry operators were working for almost 24 years. Full stop. The only point sought to be urged by Mr. Dash Leonard Kans for the appellant is that in the earlier cases noted above, there is no issue of absence of sanction posts, whereas in the present case, there is no sanction post against which the opposite party has been working, a respondent has been working. Paragraph, the court is unable to agree with the above submission. Clearly, the services of the respondent have been utilized by the appellant for over 24 years. And to permit such exploitation to continue would be neither fair nor just. Full stop. The ratio of the judgment of the Supreme Court in state of Karnataka versus Uma Devi, 2006-4 ACC 1, would apply to the facts of the present case. and therefore the case of the respondent for regularization ought to be considered by the appellant in accordance with law as directed by the learned single judge. Paragraph. Consequently, the court is not inclined to interfere with the impugned order of the learned single judge. The appeal is dismissed.
Supplementary list item number 38.
May I please, Your Lordship? Well, the appellant has preferred this writ appeal against the order dated 6/8/2021 under Annex 1 passed by the learned single judge, my lord. Lordship, kindly have a glance at page 10, my lord. The impugned order which is under challenge, my lord. The matter is taken up through hybrid mode. Had Mr. S.K. Das, learned counsel for the petitioner, and Mr. S. Jana, learned standing counsel for the School and Mass Education Department. The petitioner has filed this writ petition seeking direction to the opposite parties to revise the order under Annex 6 and take over the petitioner institution from 13/6/2006 instead of 2/3/2010 and treat him as a regular primary school teacher instead of Shiksha Sahayak. This question has already been considered by this court in WPC number 14949 of 2013, which has been disposed of by order 7/4/2021 pursuant to judgment of the Apex Court in Director Elementary Education by Dibakar Pradhan, SLP Civil Appeal number such and just such, disposed upon 16/2/2010. In that view of the matter, since the issue involved in this case has already been decided by this Apex Court in the Dibakar Pradhan Supra, this writ petition stand disposed of in terms of the said judgment. Issue urgent certified copy as per rules, my lord. But that judgment of Director Elementary Education versus Dibakar Pradhan in SLP Civil Appeal number 2104 of 2004 is different to my case, my lord. Here, my lord, my case was taken over, my lord. My school was taken over. Here, my lord, this is a case where a school was not taken over. And the Honorable Apex Court has held that it is the discretion of the state government either to take over the school or not, my lord. Here, my lord, my school was taken over with effect from 2/3/2010, where other schools, which was under the list, my lord, that was taken over in 13/6/2006, my lord.
Why don't you file a review petition?
My lord.
Why don't you file a review petition before the learned single judge? You withdraw this and file a review petition.
Lordship, I may be granted a liberty, my lord.
Counsel, the petitioner seeks to leave to withdraw the present appeal with liberty to file a review petition before the learned single judge. In view of the submission made by him that the decision of the Supreme Court in Director Elementary Education versus Dibakar Pradhan, bracket SLP Civil 2104 of 2004, disposed of on 16/2/2010, bracket, does not apply to the facts of the present case, since the school in question has already been taken over.
Yes, my lord.
By the government. So disposed of is withdrawn with liberty as prayed for.
Oblige, my lord.
Item 39.
That's item 39. This pertains to regularization of daily wage worker. Similar matters have been, yesterday also it had come up. A single judge had disposed it of, saying that you regularize. There's a delay, Millards, of 111 days, but that is during the COVID.
Delay is condoned.
Because the matters have been posted on 20th of October 2022 with writ appeal number 137 of 2022.
Just along with writ appeal 137 of 2022.
Millards, 137 of 2022.
On
20th of October 2022.
On 20th October 2022.
There's a stay of.
It's a notice. Then notice be served additionally on counsel who appeared for the respondent before the learned civil judge. There shall be a stay of the impugned order till the next day. That IA for 2282 for dispensing with, that is disposed of. The delay is also allowed to condoned.
Item 40.
May I please, Lord? Page 41 annexed.
So delays again, COVID delays.
Even the COVID.
Delays condoned. What's the matter about?
That is regarding regularization, my lord, on the single day disposal. The lordship has already issued notice in similar matters. That is WA number 137 of 2022. Same matter.
Same, okay, same order.
Item 41.
Lakshmi, turn to page 20. The delay is also during the COVID period.
This is the first hearing, is it?
Well, first the disposal. That our submission did not covered by that because in the meantime we have changed that notification that is at annexure 2, page 22. This is governing the granting aid.
Is there a similar writ appeal?
Similar writ in some similar cases that has been disposed of with a direction to file a review application.
Then we'll pass the same order. In similar matters, in a similar writ appeal, when order dated 18 January 2021, this court, in WA number 649 of 2020, this court permitted the appellant to move the single judge by way of review petition. Consequently, the appellant here is also permitted to withdraw the present appeal with liberty to file a review petition before the learned single judge in accordance with law. This post office withdrawn with liberty spread.
Item number 42.
May I please? Page 32 is the impugned. And this is the matter also during that COVID.
All right, delays condoned, dispensing with is allowed.
That matter relates to promotion during the pendency of departmental proceeding criminal case. Already your lordship has stated the matter and fixed it to 28th November.
All right,
That is WA number 33 of 2022.
List along with WA 33 of 2022 on 28th November.
On 20th November.
2028.
Sorry, madam.
20 November or 28 November?
28th November. 28th November 2022.
28th November.
Supplementary item
There should be
40.
a stay of the impugned order till the next.
My lord, I have entered my appearance in this case, my lord. Appeal memo will be given to me.
He accepts notice and then he say, complete set of papers be served.
Item 43.
Item 43 pass over.
All right.
Pass over.
Item number 44.
Item 44, my lord, may I pray this matter may be taken up on Monday? May I pray this matter may be taken up on Monday?
All right. At the request of counsel for the appellant list on Monday.
I mean, Kevin, let them serve a copy.
I'll serve.
Supplementary list for orders item 45.
49.
I am for the appellant part. Well, the appellant challenging the honorable single order, my lord, under Annex 1. Order dated 27/5/2022. My lord, the honorable single judge, my lord, not take into consider my case. I am secured 50% mark. The appellant OBC category applied general category for the post of TG Science TCM. After verification, my name was reflected and called me for document verification, madam. Page 45, madam. Page 45.
Page 70.
Impugned order simply says representation.
Yes, madam.
Why we come against the impugned order?
And it is on his prayer.
That's right.
He requested for that
Representation
direction.
to be considered.
Madam, disposed of to consider representation and take a decision.
That is already there.
Without any interim, my lord, directed to take a decision.
By now they should have taken, sir.
My lord.
This was to be taken within 2 months of the production of the certified copy. The 2 months is over.
Yes, this order was passed in the 27th May. So must have been
What is
over,
your
my lord.
grievance against this order? No. The impugned order grants permission
Annexure 1, man.
to the petitioner to the appellant to make a representation.
Man, only directed to file a representation and take a decision direct to respondent 2.
No, has notes the fact that the appellant had made a representation and directs the opposite party number 3 to consider it and take a decision within 2 months. The court sees no reason why it should interfere with the said order in the present appeal. The appeal is accordingly dismissed.
Supplementary list for orders item 46.
46 shall also be called the flag L. The appellant is dead. Convicted.
The premature, same order. I think even the next one is that 46
Item
is
40.
premature.
There is also a report of the superintendent decision taken.
That's
Not
right.
flag L plus.
No, that's 46.
Yes, 46, item 46.
46 is over. 47.
47.
The appeal is abated.
My lord, item number 47 kindly pass over.
All right.
Item number 48.
Item 48, my lord, I pray for 1 week time to receive paper book, my lord. Paper book.
Sorry?
In the meantime, I will receive paper book, my lord.
You've been served, sir. Okay. They intimated you and you're yet to go and collect it.
Yes, Lord.
You're back in jail or not?
My lord.
The appellant.
Yes, Your Lordship, his appellant is in custody, my lord.
Counsel to the appellant needs time to collect the paper books from the registry. Let's next speak.
Supplementary list item number 49.
Pardon, my lordship. My lord, item number 49, I pray for and pass over.
All right.
Supplementary list for admission item 50.
Item 50 relates to an application on the RTI Act, which normally is before the single bench, I think. Subject to your lordships, because on the last occasion, your lordships have passed an order. So if your lordships wants to hear it, also we have absolute.
List before the assigned roster bench, the learned single judge. On 13th September.
Interim order is there.
Interim order to contribute.
Oblige. 13th September.
Supplementary list item 51.
Oblige.
Item 51.
Pass out. Mr. Mishra?
Yes, but item 52.
No. Sorry, Mr. Samir Mishra.
Sorry.
51. Mr. Mishra, Mr. Samir Mishra.
Item 51.
Yes.
May I please your lord? I just got disconnected. I am extremely sorry, madam. I just got disconnected here in this appeal. Basic point that arises for your lordship's kind consideration is that whether on the basis of a direction issued by the interim trustee of the DT in question, the petitioner could have been evicted without taking recourse to the provisions of section 25 of the Orissa Hindu Religious Endowment Act. But the writ petition was filed by the present respondent number 4 before the Honorable Single Judge praying that your lordship may I just draw your lordship's kind attention to the writ petition that is also there on board before your lordship, that is WPC 446 of 2016. Page 23 of that brief was the cause of action for filing the writ petition, saying that before the interim trustee, the present appellant before your lordship, who happens to be a sublessee of the shop room in question, undertook to vacate and did not vacate. And that is how the interim trustee writes to the IIC that he should be evicted from the premises in question. And this has given rise to the cause of action for the present respondent number 4 to file the writ petition. Now, the writ petition was disposed of as per the order passed at page 29 of the present writ appeal, your lordship, without any notice to me and without hearing me. Page 31 is the order of the Honorable Single Judge. Now, this is solely on the basis that the interim trustee writes to the police saying that I should be evicted. And that is never the procedure, because this being a DT property, section 25 of the Orissa Hindu Religious Endowment Act should have been resorted to. Now, my lord, after this order was passed ex parte, I filed a petition before the Honorable Single Judge praying for recall of the same. Because my lord, admittedly, as per the version of the present respondent number 4, who is a writ petitioner, my medicines, fridge, TV and everything was there in the shop room in question. And that is also the admitted case of the interim trustee who is the custodian of the property of the DT. Now, my lord, the Honorable Single Judge at page 34 says, you sort it out with the petitioner. Instead of deciding as to whether a direction could be issued on the basis of a letter by the interim trustee to the IIC to evict me, which is impermissible.
Mr. Samir Mishra, Mr. Mishra, there is no stay passed by this division bench.
No, in fact, let me just humbly clarify. After the interim ex parte order was passed by the Honorable Single Judge, before this matter could be taken up for recall, I was thrown out. So it is case if your lordship decides that the action is apparently illegal, because it is the case of the interim trustee that I am a sublessee. Once
you're out of the property now for 9 years, at least 5 years now.
But this is by virtue of an order which is completely without authority.
No, whatever. No, do you still want to get back into the property?
I want a restitution, because my lord, your lordship will see, if at all, why I beg to point out. I just beg to point out one thing. My possession cannot be said to be unauthorized in terms of section 25 of the Hindu Religious Endowment Act, because they have accepted rent under Annex 2 at page 17 of the. They have accepted rent from me. I have paid rent in the year 2015. So therefore, my possession on the face of it cannot be in any sense termed to be unauthorized. And even assuming it is unauthorized, 25 of the Endowment Act is to be taken resorted to. And here they have completely done an action which is impermissible in law, though my lord, the interim trustee writes that the action should be as per law. And if it is
has respondent number 4 been served? Who's appearing for respondent number 4?
He did not appear on the previous occasion, therefore your lordship was pleased to refer it, my lord.
All right. Even today, none appears on behalf of respondent number 4, despite service of notice in the present appeal paragraph. The appeal is directed against two orders dated 29 January 2016 and 13 May 2016, passed by the single judge. In writ petition civil 446 of 2016 and IA number, this case number, say 3289 of 2016 in the said writ petition, respectively. Paragraph. The short ground on which the impugned orders assailed, first impugned orders assailed, is that it was passed without notice to the present petitioner. Present appellant was in fact implemented as opposite party before in the writ petition. Full stop. Since the above assertion is unable to be denied, it has not been contradicted, the court proceeds on the basis that it is correct. Since the impugned order is adverse to the present appellant, and since the subsequent order dated 13 May 2016 also does not restore a right of hearing to the present appellant, both the said orders dated 29 January 2016 and 13 May 2016, the single judge are hereby set aside. Writ petition civil 446 of 2016 is restored to the file of the learned single judge in the roster bench and will be listed there on September 2022, on which date the present appellant will remain present before the learned single judge, either in person or through a lawyer. The learned single judge is requested to dispose of the said writ petition as expeditiously as possible. The appeal is allowed with above terms.
I'm obliged, ma'am. Obliged.
Supplementary list item number 52.
But 52, if you also kindly see the order dated 12/5/2022. In this matter was subsequently after your lordship allowed the review application on the ground that the documents were not taken into consideration, though available on record. The matter was placed before the division bench, and Justice Jaswant Singh, their lordship, directed the authorities to file an affidavit, detailed affidavit, with regard to all the documents and everything that was filed, what steps they have taken in the meantime with the law on the subject. That 12/5/22 order not. After hearing, the lordship passed the order.
Correct. So what is it?
Your lordship directed on 12th May to file an affidavit. One more opportunity we gave.
All right. Mr. Kuntia seeks and is granted a last opportunity to comply with the order dated 12th May 2022. The affidavit now be filed within 4 weeks. John, if any, there to be filed for the next day.
Bhokalatnama filed by the present petitioner. The council, we have filed the fresh Bhokalatnama for the petitioner along with the appearance memo of my Lawrence Senior. The same may be taken into record.
All right. 26th October.
Yes.
Grateful.
Supplementary list item 53.
I am for the intervener.
We'll pass it over once.
Supplementary list item number 54.
There was here.
Item 54.
May I please, Lordship?
Yes, please.
The matter, in fact, requires some time to be heard.
All right.
This is regarding, Milord, let me just, I have filed a date chart. If your Lordship would permit me, Milord, I would prefer to argue it in the court on physical hearing. Today, in fact, I just returned from outside.
All right. But these are all similar matters, isn't it?
No, Milord, this is not similar. This is regarding, Milord, it's a very serious matter. Your Lordship knows that there is a fundi inside the temple, Jagannath temple. That fundi, in fact, was, Milord, established in 1983 by a special amendment of Sri Jagannath Temple Act of 1955. Milord, these are the donations given by the in the shape of money, gold, silver, other jewelries, etc. There is this specific provision. If your Lordship would turn to chapter 5.
Anyway, you want to argue it in person in the court, right?
Milord, I want to argue it physically.
All right. All right. Mr. Acharya states, who's appearing today in virtual mode, state that he would prefer arguing it in the physical mode.
The next week.
And prays for some time for that purpose. At his request, list on 16th November. Sir.
Had any certain date, may I pray?
No, sir. All right.
Supplementary list item number 55.
May I please? The matter, let's see. The learned single judge dismiss on the ground that since permission has not been granted, therefore writ petition is not maintainable.
You'll have to speak louder because you're not audible.
Learned single judge.
How much is the delay, sir? There's a delay in filing the writ appeal.
Lordship, first appeal was filed, but there was incorrect cause title. That's why my lord was pleased to permit me to last order, Lordship, to file better appeal for corrected cause title. That is what the delay caused, Lordship.
No, delay is already there, sir. Not because of some order passed with this court.
In time, we filed writ appeal, but thereafter, since when matter was taken up, my lord said this cause title wrongly typed as a teacher instead of president. So during that, it took time to file. Therefore, corrected writ appeal we filed.
You get to. What's the delay in filing the appeal, sir, that you're not answering? What is the delay, number of days delay in filing the appeal?
Let's see, during that Corona period, it was disposed of
148 days.
The petitioner, I see, is
the orders passed
72 years old.
Corona 19 cases. Sorry, Corona, yeah. The delay in filing the present appeal is controlled. In the main writ appeal, has the notice gone?
Notice has not gone, Lordship.
But they filed a counter affidavit. How's that? Opposite party number respondent 4 has filed a counter affidavit.
Respondent number 4 was not allowed as a party. Let's see, they have filed counter. Managing committee. Let's see, managing committee is the secretary. I am the president. The case, let's see, which the withdrawal of managing committee is being challenged by the president. The president, let's see, who was nominated by the MLA. First, he is a donor. Thereafter, page 22, Lordship, kindly come.
No. The ground on which the order has been dismissed.
Dismissed. That is at page 43.
Yeah, there's no authorization to file.
That's what Lawrence single judge order. But Lordship, that does not require. Because sub-collector is not the appointing authority. Law is, Lordship, 28 of the Act of Lordship, which says...
No, not appointing authority. It says, the order says, whether the petitioner being the nominee of the sub-collector.
Law does not prescribe, Lordship, for taking permission. Because he is not a nominee.
I beg pardon.
Lordship, kindly bear.
Tenure of the managing committee has long since over. It is no more. The tenure is available.
This is law.
Now the point is academic.
The law is required to be considered. The thing is, Lordship,
no, but is the issue alive? If the managing committee's term itself is over, how is the issue alive?
Let's see. It is frequent reconstitution. Let me
Annexure 8 is the approval for a period of 3 years. The approval was made on 29th of July 2019.
My lord friend is not a party to the proceeding.
I have filed an intervention.
Intervention has not been allowed. Let him permit.
I'm bringing
I'll bring everything. Otherwise, I could argue because my lord. Lordship, law requires, Lordship. The section 28 of the Act says one person should be a nominee of the MLA. One person must be a donor. One person must be a nominee, either sarpanch. Thereafter, elected member of the teacher. 11 members are required. Now, the present petitioner, being a donor and subsequently being a representative of the MLA, appointed as president. Let's see, for that purpose, I would like to take my lord
So there has to be another election, correct?
Because it is reconstitution of the governing body.
Whatever, sir, that term,
Reconstitution,
the term of the earlier managing committee has come to an end, sir.
Only thing, my lordship, I would like to take, my lord. This impediment, the illegally withdrawal of the managing committee is without any basis, lordship. If lordship does not hold anything, lordship subsequently being a donor.
See, even the single judge has not gone on merits. He's only gone on whether you're authorized to file a writ petition or not. That's all.
Lordship, that single judge has committed error, lordship. There is no law for that, lordship.
So we'll keep that. We'll say that will not constitute a precedent in case there's a dispute concerning the new management committee.
Lordship, lordship.
All right.
That should not be
the term of the managing committee has come to an end.
Should not be any impediment against.
All right. The three-year extension granted to the managing committee. An extension is
a criminal case 302 is pending against him.
Anyway, sir, what is the 3-year term? Was an extended term or
no?
Reconstituted.
The original term, 3-year term of the managing committee in question has already come to an end on 29 July 2022. In that view of the matter, entertaining the present writ appeal against the order of the learned single judge is to no avail. Stop. In case out of the constitution of the new management committee, any dispute arises, then it will be open to the appellant to agitate his grievance in accordance with law, notwithstanding the observations in the impugned order of the learned single judge.
Only thing, let's say, kindly consider I am a donor, but for establishment of the school, I have wasted my life, let's see. That's a, let's say, a reconstitution of management. They will say, since during your president as pendency as president, you are disqualified. The managing
donor involved in a criminal case, that is 302, has no right to continue as a member.
Law does not provide what my learned friend says. Law says if it is convicted.
The appeal is disposed of.
He is not a convicted person.
Supplementary list item 56.
56. Is it that? Look, let's see accordingly discount.
56.
My lord, I am the petitioner in WPC number 7274 of 2001, my lord.
Yes.
This is a sensational case in the state of Odisha, my lord. The railway link from Talcher to Bimlagarh in Sundargarh district. That was a proposal since sanction order has been given by the railway department since 2003, my lord. This is a demand from 1952. The people, those who are fighting for the cause, they have died now. Their grandsons are fighting now. My lord, this is a case. The land acquisition has not been the 3 districts. The line covers 3 districts of the state. That is Angul, Devgarh, and Sundargarh, my lord. In Angul district, some land has been acquired, my lord. But in Devgarh district, the nil acquisition. Since after 19 years of the acquisition, my lord.
Sir, if I remember right, Talcher, Bimlagarh railway link, there's some other petitions also, correct?
No, there are 2 petitions, both are now.
Now this is had to together, my lord. I'm appearing
and
for
there is a common counter affidavit filed by the land acquisition.
Your lordship, I'll pray your lordship to go through the affidavit filed by the railway in railway. They have given the details picture of the land acquisition process and their activities, my lord. But in 3 districts, there is nil acquisition after 19 years. This is a very funny, my lord. Your lordship, I pray your lordship, I will file details of the your lordship may direct the secretary revenue department to file an affidavit. In how many days within how much of time will take?
No. Perhaps my lord has not gone through the counter affidavit. That is why.
Then I have gone to
no. Kindly, your lordship.
So far, whatever you have done, that is not matter.
If you want to file a rejoinder, you by all means do that. You want to file a rejoinder?
I'll file a rejoinder. And my lord, one prayer, my lordship. In some cases, for small patch of lands, they have obtained stay order from this court, my lord. Let those cases.
Their applications will have to be filed by them to vacate those stay orders. The state will have to do it.
No, I am filing the list.
My lord, the summary of the written counter affidavit is that the matter is going on in full swing. Many places, this land acquisition process has been.
I'm ashamed to say, my lord, this is the false assurance by the state.
No, I have given the
notification saying that this is going. We are speedily we are doing the work. In 3 districts, there is no nil acquisition. 2 districts. This is the
rejoinder replying my counter affidavit.
No, this is very funny on the part of the state council to say.
Counter affidavits before the next date.
19 years after they are saying that you are going to speedily acting.
May I pray, my lord? We have already filed counter. The state has already filed counter. Railway has already filed counter affidavit, my lord. Let a copy of the counter affidavit as well as rejoinder affidavit may be served on railway, because our stand is that we have deposited the 1,000
yes, we have
to the
deposited
state
everything.
government, but they have not acquired the land.
They have not utilized the half percent of the deposit they have railway made. And the land acquisition officers are sitting, changing month by month, my lord. Nobody is taking care.
We have already disbursed 101 crores of rupees in para 12 of my contract.
No. He says there are still 3 districts. No acquisition
in 3 districts, substantial progress has been made, and disbursement.
Let my lord and friend file an affidavit.
That is affidavit. The affidavit.
Section 9 is.
What is Anugul district? What is Deoghar district? Everything has to be detailed.
Your lordship, allow me some time. I will place the affidavit.
Supplementary list item number 57, 27th October. Item 57.
Lordship, that deed petition, first order your lordship may kindly produce. I'm sorry. While issuing notice,
your lordship fix a date.
12/4/2021, order number 2.
No, maybe. Now, why is it rosters?
Am I audible?
1 minute, sir. 1 minute. Sir, let's just place it before the assigned bench. Place it before the assigned bench. On when do you want it, sir?
This is not I don't know, Milord. I filed a one. There is some technical problem, I think, from my side.
19th September, so we'll place it on 19th September.
19th September.
Right.
Is it coming before my order?
No, before the assigned bench, sir. Because this is not the bench assigned to hear this matter now.
Your lordship have had it on not less than 10 occasions.
I know. Earlier we did hear it, but now the roster has been changed. So we are not the assigned bench. That's why. All right.
Supplementary list item 58.
May plus me turn to page 60, annexure 7.
Delay is what?
During that COVID.
Corona period. All right.
page 60, your lordship may say annexure 7.
Yes. Fire officer.
His case was rejected taking into account 2020 rules.
So this is now covered by
Yes, ma'am. Then
against you by Justice M.R. Shah's judgment. So the appeal will be dismissed, sir.
Yes,
Because the judgment given by us has been reversed by the Supreme Court. That Malayan and the Sethi's judgment has been reversed.
But the lordship in similar matters is urging the matter because the matter has been referred to larger bench. Yes, SBI versus Shivasankar. This is 2-bench judgment. The matter has been referred to larger bench.
Stated that the petitioner is a victim of delay caused by the state pillar.
No, I know, but here itself they've noted, I think, in page 3 that the matter is before a larger bench.
Yes. NC Santosh.
Just see para 2.2.
Sorry, ma'am.
Paragraph 7 mila. May I read from paragraph 7 mila? That you got it? Thus, from the aforesaid, it can be seen that there is no fault or delay or negligence on the part of the appellant at all.
No. There is a reference made here to the fact of reference to a larger bench.
Not here.
No reference. In that Malananda City case, no reference has been made.
No reference.
But in this NC Santosh case, that reference has been shown.
In NC Santosh.
Well,
2010 Miller applied for Miller 2010. So much of delay.
And your lordship in WPC
selected Miller. The entire selection process is over Miller. Only appointment letter was issued, was to be issued Miller.
Your lordship in WPC number
documents also
3755 of 2020.
To Miller.
A deferred the matter
by the authority Miller. Original documents verification was made Miller. The police report has come also Miller. The medical examination report has also come. Only appointment order was to be issued. Before the 2020 rule came into force Miller, everything was the entire selection process is over Miller except issuance of appointment order.
That NC Santosh, do you have that reference to a larger bench, the judgment in NC Santosh?
Yeah, that is SBI versus Shivasankar Tiwari 2019 5 SEC 600.
Para
16 of that.
That has been referred to larger bench. So Malananda City case is passed by the 2 bench. And accordingly, your lordship in WPC number 37575 of 2020, I referred the urgent the matter signed by till disposal in before larger bench.
Where is that?
That is WPC number 37575 of 2020. By order dated by Lord 27th July 2022.
All right. No, last time you were showing us the copies of those orders. What happened?
Where's the copy? I have it in the lecture.
Or you should actually share it here with us.
I can share.
It is pointed out that the issue concerning the rule that is to be applied at the time of considering the case of an applicant under the rehabilitation assistance scheme has been referred to a larger bench of the Supreme Court in SBI versus Shivasankar Tiwari 2019 5 SEC 600. That view of the matter awaiting the judgment of the larger bench, the present appeal is adjourned sine die with the permission to the parties to mention it for listing after the decision of the Supreme Court. All right.
59 is also same. 15 next item is also same.
Same order in the next one.
Supplementary list item number 60.
Item 60, we were required to file counter matter where the draft is preparing. So some time may be given in the meanwhile. In 3 weeks, we will file the counter.
Counsel for the
NCRT will file the counter.
All right.
I'm for the opposite partner 6 matter. I've also received instruction. I will file it.
My lord, I am for the intervener.
All right. Mr. P.K. Paddy, learned counsel for the learned Assistant Solicitor General, appearing for the NCERT, states that counter affidavit will be filed on its behalf within 4 weeks.
Within 4 weeks.
What about the others? You have filed your counter.
I'm for the copy number 6 matter. School and market. Also received instruction. I will file it.
Likewise, Mr. Mahapatra, appearing for the School and Mass Education Department, states that he will file his reply within 4 weeks.
I appear for OP number 7. I have not. All for the instruction and
Similar submission is made by counsel appearing for the CBSE. Rejoinder there to any file. Has notice gone in your intervention application?
Not if I had filed. My lord, I had filed the intervention application. I have.
This is 5256.
5256.
All right. And IA 5256, you say notice accepted by the counsel, the petitioner, and all other counsel.
Well, notice has already been sent, madam. I have already sent the notice of the intervention application also.
No, has notice already been issued?
Last occasion also directed to send the copy of the intervention application along with the notice, madam.
All right. Replies also be filed to the intervention application within the same time period. Rejoinders, if any, to the replies be filed with the next date. 27th October, sir. 27th October.
Supplementary list item number 61.
Item number 61. Counter has not been served, Your Lordship. For the IA 10796.
9056.
My Lord, your Lordships called upon me to appear and assist your Lordship. Would your Lordship see the last order minutes?
Yes.
My lord, my intervention petition may be admitted.
We'll consider all of it, please. Yes.
Kindly see, my Lord, 8th of August 2022.
Right.
The court has perused the affidavit filed by Sashi Paul, Principal Chief Conservator of PCCF and Wildlife Warden Odisha, who is also present online. While better details of 14 cases involving illegal poaching of elephants in the last 5 years have been furnished, it is plain that mere registration of these cases has not yielded desired results of deterring the offenders from pursuing with their crimes. The progress of the cases is also not satisfactory. Except in one of the 14 cases, trial has not yet commenced in any of them. The affidavit explains that the STF crime branch is dealing with the host of problems apart from wildlife-related crimes such as interstate drug trafficking, tender fixation, extortion-related offences, gang robberies, etc., etc. Kindly see para 4. Clearly, the STF is overburdened, cannot be expected to devote special attention to the task at hand, considering that the increased number of deaths in elephants of Orissa and recent was alarming. A concerted effort has to be made to activate the law enforcement machinery for strict enforcement of Wildlife Protection Act and other related laws, including the Arms Acts, as in many cases these elephants were found dead or grievously injured with bullet or pellet wounds. It is surprising that none of these cases so and so. The court considers it appropriate to call for an affidavit from the DG Police for his views as to how the problem should be tackled, in particular how the investigations can be expedited, the accused arrested, filing of charge sheets, conduct of trial be expedited, affidavit to be filed on the next date. Now, my lord, we have filed an affidavit. Your lordships kindly have a look at it.
Yes.
My lords have the affidavit
of the DGP.
Of the DG Police, fellows.
Right.
My lord, before I read the affidavit,
Yes.
Would your lordships have a look at the minutes of meeting? Because
Right.
that is exactly what has been said in the affidavit.
Okay.
So it is page 5,
Right.
annexure A/4. My
Right.
lords have it, my lords.
Yes.
This is a meeting held on 17th of August. The meeting was held under the chairmanship of so-and-so to discuss the recent deaths of elephants in different districts of the state and devise. I'm so sorry, my lords. I'm so sorry. Lords, a 6-page affidavit.
Yes. Yes.
My lords have it, please.
Yes.
Lordship, please. A meeting was held under the chairmanship of so-and-so government of Orissa to discuss about the recent deaths of elephants in different districts of the state and devise a mechanism for their protection. List of officers at so-and-so. After thorough deliberation, the following decisions were taken. A joint task force comprising of officers from the police, forest and police department would be constituted to investigate different cases of unnatural deaths of elephants in the state. The joint task force will work under the PCCA Wildlife in his office. The Director General of Police Odisha will provide requisite number of police officers of different ranks to act as a member of the task force. The composition of the task force will be decided by the DGP Odisha and PCCA while together at the earliest. The task force will also look into the cases of poaching of tigers, leopards, and illegal trade of pangolins. The cases having involvement of interstate gangs or overseas connections will be investigated by STF of crime, as is the practice now. In order to expedite the trials pertaining to the wildlife offences, specifically cases of poaching pending before trial courts, one public prosecutor in each district will be entrusted with handling of these cases. The Honorable High Court will be moved to designate the Chief Judicial Magistrate, Additional Judicial Magistrate in every district to exclusively deal with wildlife offence cases. The state government will take special measures to create awareness about the protection. Now, your lordship will say, what is the meaning of earliest? Your lordship should say, 3 to 4 weeks, this task force will be constituted. And that is precisely what is the affidavit of the DG Police.
May I please, Madam?
1 minute, sir. 1 minute. No, these PCCF, the details he has given.
Lordship, please.
So you'll find case after case, charge sheet not filed, charge sheet not filed.
Yes, well, therefore, my lord, what we are now going to do is, there will be a task force now who will exclusively look into this. It will comprise of the forest officers and the police officers. We will have a designated PP who will only look after this.
No, but there should be some time targets to file the charge sheets.
My lord, your lordship may say 3 months. In addition to whatever has said, your lordship should add those riders. For example, we have said at an earliest, your lordship may say 4 weeks. And charge sheet, your lordship may also say 90 days. If your lordship says, I will file an affidavit, or otherwise your lordship may say that.
Well, let's say delay procedure has been adopted, my lord. Well, in the counter affidavit, they have not raised about the Arms Act, my lord. They have not discussed about the Arms Act as per the para number 4 of the last directions, my lord.
See, now there will be police officers in the task force, so they will file that under the Arms Act. That's not a problem.
There's a supplementary charge sheet itself have to be filed there. What are the preventive steps taken? That's not clear at all. We're all the time reacting to something that has happened.
Your lordship is right, your lordship is right. The cause is the larger issue.
Yes. So by now, with so many deaths having happened, a pattern would have emerged. They should have unearthed, if there are some gangs operating, they should have unearthed the operation of those gangs. What are the preventive steps? We don't seem to be any concerted effort at a preventive step.
If I may just add that
Killed this by the gangs alone, they don't get food in the forest. That is the whole difficulty.
this issue came up before the Karnataka amendments. Before Karnataka, it came up. The Karnataka High Court has formed a cohesive, the judgment is a part of WPC 22421 of 2015, where they have laid down guidelines to prevent this man-animal conflict. So they have balanced out both. And of course, there was an STF constituted there, and they have come up with solutions to prevent. So preventive mechanisms are there in that judgment.
It's Sumoto versus State of Karnataka.
Correct. Your
Worship, similar order has been passed by the state of Tamil Nadu also. I filed in my affidavit also.
So maybe the government can look into those suggestions there. That's already with them.
That's on the man-animal conflict.
Your Lordship.
But we are on a additional issue here of actual poaching.
Tamil Nadu High Court has already passed an order. I have filed in my affidavit dated 17th. Page number 6.
My lord, it is also attracting to my first prayer, my lord, where I prayed for the amendment of the wildlife as in the style of Assam government, my lord.
No, which is your affidavit?
Affidavit dated 17/8/2022. Purabi Patra. I have already. It has.
My lord, may I suggest
that's
something?
Right. That's right.
They have directed CBI to inquiry it.
No, but
because
we can't simply go all over the place now. Yeah.
Because there is actually a contradiction. They are saying these are poaching. We are saying we are saying these are poaching. They are saying these are not poaching because they are poison.
No, I don't think they are saying this.
No,
as far as Orissa is concerned, I think they are not. That's not their stand.
Because they have.
My lord, we have set out an affidavit as to what would be done. What your lordships are asking me is what are you doing to prevent these things from happening?
Correct.
So one is post and one is pre.
Correct.
So what is to be done and pre? Your lordship may give me 2 weeks time. I'll come back with a better affidavit.
But then you can take into account whatever has been said in the other two.
I will look at both Tamil Nadu and Karnataka, my lords.
Correct.
No, and the counter of the affidavit may be filed because we are stating these are animal related poaching, but they haven't filed in their affidavit. So let them file whether these are poaching related cases or.
And you can look into the Assam situation, which Mr. Mishra is pointing out, whether Assam has had a different approach.
I will look at Assam.
Right.
I will look at Tamil Nadu. I will look at Karnataka, my lords.
All right.
My lords.
My lord, beside I have also given an information, my lord. One elephant is also moving inside the Adgod, my lord, with 3 bullet marks, my lord. As it has come out in the different newspaper, and I have submitted that document.
Today itself, 2 elephants had died. Today itself, in Keonjhar district. I can have the news clipping only I have.
No. I have checked up their electrocutions. They went into a farm.
2 days back.
My lord, it's not 2 days back. They went into a farm today morning at 5 o'clock in the morning.
Coming into the.
Where is that?
I'm on the other part, my lord. This is one part of animals using firearms. I'm on the other side. The animals are not getting water and the government has stated that it has spent 26 crores of rupees for development of forest and for living of the elephants. That is to be looked into.
See, usually, Mr. Parija, the movement of elephants is quite predictable because they follow certain patterns.
Correct.
And because of intense mining activity in Keonjhar and other places, they're having to change their routes.
The elephant corridor, your lordships are speaking.
That's the original traditional corridor which they themselves formed have all got interrupted now.
Right.
So which is why they're now coming into, that's why you have more of these situations of electrocutions and all of that.
My lord, I was just wanting to find out from my juniors, my lords. Elephants eat for about 16 hours a day. And what they get in the forest is mostly bamboo and foliage. So they look to more nutritious food. And I'll file an affidavit. And that is mostly paddy and wheat.
That's what, they've all got used to that.
Yes.
No, but where is the involvement in this, what you have given to us?
Yes, my lord.
Where is the involvement of wildlife experts?
My lord, there is no necessary departments are not parties to this committee also.
No, 1 minute. So we need to have.
So therefore, my lord, wildlife expert will really tell us the cause.
Correct. And also to predict the patterns,
Yes.
anticipate for
Yes.
all those preventive measures, you need
Yes.
wildlife experts.
Right.
Lordship, if your lordship permit me, even in 2010, there were similar related cases in Shimlipal. NTCA has filed a committee, independent committee, and they gave a suggestive measure. I have filed in my affidavit dated 17/8. They have given the reason for poaching and what are the causes also, and what are the suggestive measure. And after that, I can say somewhat has reduced in Shimlipal. But they let there be a independent committee, if the learned senior accepts that, to investigate what is the cause and what can be the preventive measure. Let there be an independent wildlife committee.
I have no issue. I have no issue at all. But ultimately,
I think this joint task force should co-opt some wildlife experts.
Yes.
Your lordship.
We will say that.
All right. All right.
My lords, in this matter, my lords, I'm appearing in person for one of the cases. My lords, here my focus is on man-elephant conflict, my lords, which arises only when the animals destroy the crops, agriculture crops, and property.
Correct.
In this context, my lords, I would like to make two humble submissions. One is when we are talking about what is to be done for the future. My lord, learned Supreme Court has dealt with these matters of human-animal conflict, particularly in T.N. Gandhamardam, your lordship knows. So I've got copies of the judgment for your lordship, but from the India Kanun, which gives certain perspective to this man-animal conflict. Secondly, my lord, till date, lot of crop has already been devastated by the animals. They need to be compensated, the farmers, my lords. So that compensation process is very, very meager and it's very, very slow, my lords. If in the meanwhile, let them pay whatever compensation to the crops already destroyed by the wild animals, my lords. So therefore, there are two aspects. One is futuristic, certainly task force, as it fell from your lordship, also having representatives of animal experts and representatives of probably NGOs or farming community who will give in their inputs as to why their side of the conflict. And number two, to compensate people who have lost their crops. My lord, that is leading to a lot of migrant laborers. They are abandoning farming totally because of this uncertainty. Third, my lord, in a lighter vein, ultimately, I think, as your lordship had once said, cooperative Hanuman will only help us.
This is not adversarial at all. So we have a STF. My learned friends have suggestions. Your lordship may say we will add experts there. And let me have a look at those judgments.
And I think they're also looking at broadening the area of
whatever it takes to save lives, it's always welcome. Whatever it takes to save lives of elephants, for that matter.
No, and of human beings, both.
Yes.
We have to avoid those instances of conflict, man-animal conflict.
Lordship pleases.
May I just have a suggestion subject to what the AG says, to make it easier for him, since there are so many councils, if they can summarize each of us our suggestion, then give it to the AG.
Yes, that's very fair. That's very fair.
So that interveners, everybody can just summarize. It will be easier for the learned AG to look into our suggestions and pick up the best.
That's the best. That's the best.
Besides, my lord, I would like to bring the attention of the Honorable Court, my lord. There is a resolution of our joint forest management that was in the year 2011, and that has not been followed, my lord. And this is the basic cause for elephant death, my lord. And that has been already attached in one intervention petition, my lord.
Yes, my lord.
In 11195, my lord. They are neither they are conducting the meetings, my lord, neither they are operating, nor they are involving the local people, my lord.
Give me a one-page note. We'll have a look at it.
Yeah. You say, pursuant to the order passed by this court on 8th August 2022, two affidavits have been filed in court. The first is by the Director General of Police, in which the minutes of the proceedings of the meeting held on 17th August 2022 under the chairmanship of the Chief Secretary, Orissa, has been enclosed. Full stop. A decision was taken at that meeting to constitute a joint task force bracket JTF comprising officers from the forest and police departments to investigate different cases of unnatural deaths of elephants in the state. Full stop. This JTF is to work under the Principal Chief Conservator of Forests bracket PCCF bracket wildlife in his office, and the DGP is expected to provide the required number of police officers of different ranks to act as members of the JTF. Paragraph. The JTF is to look into cases of poaching of tigers and leopards and illegal trade of pangolins apart from the deaths of elephants. Full stop. One public prosecutor in each district is expected to be entrusted with the handling of these cases. Full stop. There are certain other tasks set out for the JTF, including creation of awareness about protection of wildlife, open quotation, among all the stakeholders, unquote. Paragraph. Conscious that the proceedings do not commit the JTF to any definite timelines, and considering that the other affidavit filed today by the PCCF enclosing details of the pending cases shows that in a large number of cases charge sheets are yet to be filed. So the Advocate General volunteers that the necessary corrective steps would be taken within 3 months, and within the same period, charge sheets would be filed in all those cases where they're yet to be filed. Paragraph. The court finds that while these are the steps proposed are in the nature of single quotes remedial bracket unquote action, there is nothing much in terms of single quotes preventive unquote action. Further, the court finds that the JTF is not broad-based to accommodate the views of wildlife experts, civil society groups working with farmers who may have lost their crops, and other interested persons engaged in the issue of man-animal conflict. We'll stop. The learned Advocate General volunteers that the JTF will either co-opt wildlife experts and civil society groups or consult them in all its deliberations, which will take place at least once every fortnight, so that a comprehensive action plan can be drawn up, which will include both the preventive and remedial elements. Paragraph. Considering the number of petitions raising this very issue are pending before this court, a direction is issued that the counsel in each of these petitions will prepare a short summary of their respective suggestions and provide them to the Advocate General within a week's time for him to examine all those suggestions and place it before the JTF for its consideration. Full stop. This would include examining the orders of the Supreme Court in T.N. Godavarman Tirumulpad versus Union of India, bracket order dated 13th February 2012, concerning the single quotes Asiatic wild buffalo, unquote. The order of the judgment of the Karnataka High Court in
Suomoto versus State of Karnataka and others, WPC number 14029 of 2008.
Suomoto versus State of Karnataka, bracket WP number 14029 of 2008, the judgment of the Madras High Court in
S. Manoj Emmanuel versus Union of India, WP
Emmanuel versus Union of India,
WP in brackets MD 19771 of 2018.
Of 2018. Full stop. Further, the measures taken by the state of Assam tackle similar problems in that state concerning elephant-human conflicts will also be examined by the JTF. Paragraph. Who is going to be the convener of the JTF? The PCCF. Considering that the PCCF is going to be the convener of the JTF, a direction is issued to the PCCF to place before this court, along with an affidavit, the comprehensive action plan before the next date. The court takes note of the fact that there have been more deaths of elephants even after the previous hearing. Full stop. The court has been shown a news item that only this morning 2 female elephants were electrocuted inside the Krishi Vigyan Kendra in Judea under Kionjur Sadar. Full stop. The JTF would.
There's a short instruction. Yeah, speak on that.
Yeah.
Happened today morning. Appears to be a food problem again. They've gone into a farm.
Yeah.
Food problem.
That's right. The Advocate General further states that he'll file a further affidavit on the results of the investigation into these deaths and place them on record on the next date. So we'll have a hearing in September itself.
There is one more Supreme Court judgment. I didn't want to trouble your lordship. It's a recent 2020 that may also be included.
All right, include this also. Hospitality Association of Mudumalai versus In Defense of Environment and Animals, 2020 10 SEC 589.
My lord, one more thing.
Last week of September. End of
All right.
My lord, since it's such a high-level committee is likely to be constituted, my lord. So instead of limiting it only to elephant, can we make it man-wildlife conflict?
No, they've already got 3 or 4 animals there. Pangolin, tiger.
We have also raised the loss.
All of that.
Boars also, my lord, wild boars.
In the petition, we have also raised, my lord, loss caused by elephants. That is also to be your lordship to consider.
Your lordship, in the committee, maybe include counsel for the interveners also. It is counsel for the petitions.
Okay, petitioners and interveners. All right.
That's also my suggestion for your lordship's consideration. But there are certain people who are developing the forest. In the task force, we hear the petitioner in 9056, the MP and 3 times MLA. But such people can be taken into consideration in the task force so that they can suggest many things.
So they can still suggest it to this task force, sir. They don't have to be part of it. I think the task force, if it can receive suggestions from all quarters, that's fine. That should serve the purpose.
In fact, if the learned AG is there in it puts his mind, then we definitely have solutions. So,
my lord, I pray, my lord, let us sort of clarify on the resolution dated 9 September 2011. So for joint forest management.
So whatever you put it in the note and give it to the AG, sir. Everything does not have to come into the order. We have said that whatever suggestions you have, please put it in the note and give it to the AG.
I pray about the petitioner should be included in that task force.
No. You give your suggestions. You don't have to be part of it. The leaner the task force, the better. It can function in a more cohesive way. If it becomes too unwieldy, then that's also a problem. 26 September?
Lordship, please.
26 September. All right.
Lord, I would only make a small request, my lord.
Yes.
That if these suggestions can come within 3-4 days, then I can have to forward it.
I've said a week. So
Lordship, please. That week is fine. No,
right.
I'm so sorry.
Right.
We are all grateful.
Passover items.
Supplementary list passed over matter item number 14.
49.
14 through.
$35 is one.
Item 14.
None appears despite a Passover. This was not possible.
Item number 28.
Despite a Passover, none appears. This was a non-prosecution.
Item number 35.
Miller, please. This is the PL Miller, held by the villagers Miller. Miller, the government land that has been recorded in a name of a person, the moneyed person, but due to illegality done by the government Miller, kindly turn to page 43 Miller of the read petition Miller. Page 43 Miller.
No, this representation which is at page 30, what's happened to it? You've given a representation which is at page 30.
Miller, that has not been taken up in the constituency Miller.
No. What is that to show that it was delivered?
No, there is no endorsement for that.
No, that is Miller. 144 case was filed by some villagers Miller, and the executive magistrate, they gave some interim protection.
My lord, have a glance at page 28.
My lord, page 43 में kindly see. ठीक है, रूम में कोई सा है? ठीक good sir. Page 43 में kindly see. Only for payment of 50 rupees Miller, 500 ports landed property of the government Miller has been handed over to the private person Miller.
Have you made a representation at all or not?
Miller, yes Miller. In that is Miller annexure 2 series Miller.
No.
Yes,
what is there to show that you delivered this representation to the collector?
Miller.
I've asked you a question, sir.
Miller.
You asked.
Proof kon achi deicha boli delivery korche.
Coming to the collector office Miller, they have given Miller. Coming to,
enough,
and now they are not giving any.
No.
Nothing.
That's not even correct. We have ourselves seen postal receipts. It's not correct, sir. What you're saying is not correct. If they're refusing to receive it, you can always send it by post.
They've given Miller.
My lord, for last 50 years, this land is in favor of a private party, and it is the annexure which he has relied upon. That is the latest settlement record of right. And now they are saying that is why this litigation has cropped up. So
let him make a representation. You say permitting the petitioner to make a proper representation to the authorities, and after following up on such representation,
collector is there
to seek appropriate remedies in accordance with law. The petition is disposed of. All right.
But in the meantime, they are now going to
better get your act together, sir. Make a proper representation. Make sure it is delivered. Only then you can follow up. Yes.
Pastor matter item of 43.
43. 43.
Item number 43.
1 minute. May I please, your lords? Right here, the respondent number 1 to 4, they have found to be serial encroachers or chronic encroachers. Proceedings were taken up time and again. That your lordship will get from the collector Kendrapada's disposal at page 37. Can I take your lordship to my lord? Page 37. And the page 41 would be more relevant, that they are chronic encroachers. In 2017-18, encroachment case number 491, 492, 93, 94, all 4 belongs to one family, my lord. It was taken up. And the Tahsildar Angul took up the the process under the Act, and they were evicted on 13th June 2018. I'm referring page 42, my lord. Again, 2018-19, 4 encroachment case against the very same persons, my lord, 23, 24, 25, and 26 of 2018. Their application for grant of lease in their favor as landless and homesteadless, that was also considered and it was rejected 31st July 2018. Third one, my lord, it was taken up for again removal of the encroachment 830, 32, 31, 33. This was in 2018 and 19. Now on this occasion, my lord, on 16/3/2019, 1.5 decimals of land in favor of each of the member, 4 persons, were leased out in their favor. And later on, upon inquiry, it was found that the family is having 13 acres.
And the notice is not gone in this appeal.
No, my lord, it's a notice.
Or say notice. This must be a private party here. No?
I am appearing for 1 and 2.
Mr. Mohanty accepts notice for 1.
I'm sorry, 5 and 6. I'm
5 and 6.
Collector and Tahsildar, my lord.
Notice be issued now to opposite parties 1 to 4 by registered speed post. Additionally, notice be served also through counsel appeared on their behalf for the London Single Judge.
No, process of change in record so far as status be kept in abeyance till then, my lord. Because of this the honorable single bench order, my lord, the Tahsildar is
what?
Taking a process for.
Let's see what he does. Anyway, notice on that stays.
Yes, lord.
All right.
Much obliged.
Returnable on 9th November.
9th
November.
Much obliged.
Pastoral matter item number 47.
47, your lordship. I'm on VC, your lordship. That application for bail, the criminal appeal, your lordship. The present appellant is inside custody, your lordship, since 25/6/2011. It's more
Are you
than
ready
11
to,
years.
are you ready to argue the appeal, sir?
No, my lord, the paperwork is not ready, your lordship. On the notice.
All right. We'll ask it to be made ready now within 4 weeks.
Paperbook is not ready.
Yeah.
Paperbook is not ready.
Right. Paper
Lordship, I'm
books.
not shying away from arguing a criminal appeal, but let him go on bail for some time, your lordship. He's
No,
inside
what is it?
custody
Not for some time,
11
meaning
years.
what? Are you asking for interim bail? Then you make out a ground for interim bail.
There is long delay, your lordship, in hearing criminal appeal.
I know, which is why we're trying to do our best to expedite, at least where persons are in custody. So if you're ready to argue in respect of persons in custody, we're happy to hear it.
As your lordship.
The paper books be readied within 4 weeks and be supplied to counsel for the parties. List for final hearing on 14 November.
Pastoral matter item number 49.
Please, your lordship. The appellant faced trial being charged under section 302, 201, 25, 27 Arms Act and convicted under section 302, 25, 27 Arms Act. Sentenced to undergo a for life, my lord. My lord, in this case, the petitioner, now the IF for bail, my lord, the PW2 is the eyewitness to the occurrence.
How long has he been in custody?
Custody since, my lord, 23/2/2012, my lord.
10 years.
More than 10 years, my lord. And the petitioner avail 3 interim bail and surrender for treatment of his wife.
Which is this IA?
My lord?
IA.
I-1015, 2017.
What are your instructions?
Regarding plus instruction, plus only on merit, I can say the submit for lordship. That is, your lordship will come to paragraph 7, internal page 6 of the judgment.
No, this is a case of direct evidence.
Yes, direct evidence. Only one eyewitness.
It is a case of
only one
accident.
eyewitness is there.
It is a
People
case
too.
of accident. I am placing the eyewitness statement. There was no enmity. Both are friends. Both are watching TV, and it is the evidence of the IO that they both have purchased a revolver. And on the date of occurrence, both were watching TV inside the house of the deceased and the present petitioner, along with some others. They were watching TV inside the house of the present petitioner, my lord. They both came out, and the PW2 also came out. Suddenly, the PW2 saw the petitioner fired, and the deceased sustained injury. Immediately, the appellant shifted the deceased to hospital on Angul in absence of his parents, family members. Thereafter, the father of the deceased arrived at Angul hospital. Then all the present appellant and the father of the deceased, they shifted the deceased to Cuttack. On the Cuttack, he died. Then all have.
No, is this single bullet wound?
Single.
Where is that bullet
Paragraph
wound?
13, your lordship.
My lord,
Page 10, internal page 10, paragraph 13.
And the postmortem report shows that it may be a case of homicide, suicide, or accidental. PW9 stated. IO stated that they both have purchased this revolver, my lord.
One injury marked, deep punctured, lacerated wound.
Yes.
Cranial cavity, so in the head, below the left eye. So the shooting in the face, basically.
The nostril, my lord.
And the metallic bullet has also been recovered on us. From the bottom, 3 lines above.
No. 1 centimeter below the medial of the left eye, sir.
Yes, yes. It is accidental, my lord. The prosecution has not brought any evidence that there was any enmity between both the parties. They are friends. Both were watching TV on the date of occurrence in the house of the appellant, my lord.
No, let's see. PW9 is the who's the eyewitness?
Eyewitness is PW2, my lord.
2,
my lord.
Where is that discussion?
My lord. I am placing, my lord, PW2. Paragraph 2. The incident in question took place about more than 3 years back, around 9 p.m.
No, where are you reading, sir?
My lord, PW2, paragraph 2.
No, where is that?
Deposition have
the copy has not been supplied. My lord, has not supplied the copies of the depositions.
Copy of the deposition I have supplied, my lord. May I place, my lord?
1 minute, let me just locate it. LCR is there, so we can probably get it from the LCR. So LCR is also not bookmarked. It's not the LCR, it says. But he's supposed to file copies. Where is that? What he's filed? So he helped recover the weapon of offense.
Yes.
Was there a statement made to
Yes.
leading to the recovery of the weapon of offense?
At the instance of father of the petitioner, at the instance of father of the petitioner.
I see.
That your lordship will get it from paragraph 16, page 13, page 13 of the judgment.
Right.
Start from on 23rd February 2012. That starts from the bottomless 5 lines above.
I think you can just read.
My lord.
Because if you don't seem to have another copy, right?
So I have from this judgment I am placing, my lord. I am also supplying the copy. PW2 is the eyewitness.
Yes. Yes, please. Yeah. Yes.
My lord. PW9 is the father of the deceased, my lord. PW9, father of the deceased, in his cross-examination, he admitted the post-conduct of the appellant. He shifted the deceased to hospital first at Ongul, then to Cuttack. PW8 is the doctor. In cross-examination, admitted that it may be case of.
No, you were beginning to read PW2, weren't you?
My lord, PW2 paragraph 2. I have not the copy. I have only single copy was there.
You also don't have a copy.
No, my lord has not also supplied a copy today.
All right. We've just read it.
May I place, my lord?
Yes, please.
My lord. The incident in question took place about more than 3 years back. Around 9 p.m., I had gone to the house of accused Lakshman Deori for watching TV. In the shade room where I was watching TV, accused Lakshman Deori, accused Lipon Deori, the present appellant, mother of the accused Lipon Deori, namely Rebati Deori, wife of Lipon Deori, and the brother of Lipon Deori, Hitesh Gadnaik, were there. Hitesh Gadnaik is the deceased, my lord. At that time, Hitesh Gadnaik came out and accused Lipon Deori followed him.
I also came out of this house for urination. Accused Lipan Deuri fired a gunshot from a Mauser and killed Hitesh Gadnaik. I went to my house out of fear. This is the statement. I am permitted to place the deposition of PW8, the doctor. The doctor, in his cross-examination, stated that no gunpowder was present over the region of the injury. The injury found by might be homicidal, suicidal, or accidental. I am permitted to place the.
No, but there's nobody's case it's suicidal. So let's not.
No, it is not a case of suicide, my lord.
So what is there to show it's accidental? That's the only
Yes,
question.
my lord, accident, my lord. And the father of the deceased, he stated that accused Lipan Deuri, myself, and one Boga Behra went to Kotak accompanying my injured son. I could know on inquiry from the accused Lakshmana Deuri that my son Hitesh was shifted to Chandipada Hospital for treatment with the accused Lipan Deuri and his brother-in-law. Accused Lipan Deuri was also accompanied us from Chandipada Hospital to Chandan Nursing Home. Accused Lipan Deuri also returned in our vehicle from Kotak to Chandipada. And the IO.
The only what we're not able to explain is why would the accused go along?
I had mentioned.
What is the defense? What has he said when asked under 313? What has he said? Under 313, sir. What has the accused said? How does he explain this?
My lord. No knowledge, my lord.
How can he say that, sir? You can't then say it's accident. So this is the whole problem.
My lord,
this is a standard reply then.
That you will also get it at page 22 also.
Of the trial court judgment.
Yes, please. Page 21 regarding the opinion of the chemical examiner. 22 on 313 safety statement.
So it's better we hear the appeal itself. I think that's better. Let's hear the appeal itself. You say the paper book we prepared within 4 weeks. Set down the appeal for hearing and supplied to counsel for the parties. The appeal is set down for hearing on 21st November. All right.
Pastoral matter item number 53.
Mike, switch on the mic.
This is regarding fixation of headquarter of a panchayat office.
Hmm.
Headquarter is running since long and it is dispute with.
All right. None appears for the appellant despite a passover. Dismissal non-prosecution.
Hearing back.
Yesterday there was some mentioning in the other day, we listed an appeal for hearing. We in fact specifically asked counsel if he ready to argue, he said he will. Anyway, follow.
Supplementary list for hearing item 62.
I humbly pray, last occasion, your lordship has heard item 67. That part on section 149 CRPC. That matter your lordship has delivered a judgment just 2 days back, and that I can finish. My how is also present.
60?
62 called out the first.
Mr. Panda was there.
Your lordship, in item 62, I am there on behalf of Mr. Panda. Your lordship, can it be taken up after lunch? Because Mr. Panda is on his legs.
All right. Take it up after lunch. All right.
Obliged, your lordship.
Item 63.
Your Lordship, in item 63, on behalf of the conducting counsel, Ms. Bini Mishra, Your Lordship, she hasn't recovered from the accident as of now. I pray that a short time may be given, Your Lordship.
All right. How long will it take for her to be recovered?
Your Lordship, probably next week she may be ready to argue. I have no such instructions as to that, but I know for a fact that the bandages and everything haven't come off
All
as
right.
of yet.
At the request of counsel for the appellant, list on 22nd September. All right.
Much obliged, Your Lordship.
Item 64.
Your Lordship, item 64 as well, Your Lordship. I pray
All
for
right.
appellant.
All right. Anyway, lunch is here. All right. 1991 matter.
Yes, plus. I can answer.
So we'll take it up soon after.
Yes, plus that 67, the Darasing matter, which was parted, of course, in a different bench. That also will also can take up. So that
yes, we'll come back up.
65, Your Lordship.
A copy of the letter I sent to my lord. I have given that copy.
All right.
Bala.
may start the government appeal.
Government of
Item 1.
No, what about the remaining?
The supplemental list. Supplemental list, item number 64.
What happened to 63?
63 adjourned to 22nd September.
Ah.
Hmm. 62 and 64 have somehow after lost their question. Mr. Paul.
But I saw him here in the morning. You're ready with your weekly list matter?
Yes.
We'll start with that. Because we're waiting for these people, we might as well finish that.
Government appeals. Yes, please. I'll start. The background of the case is there is a group rivalry in a village. They belong to one political party. That is one aspect, and also there is land dispute between SC community, scheduled caste community, and these are higher class community. So there is a long-standing rivalry between two groups. That is the reason why ultimately this occurrence has taken place, and the Banamar, the deceased, has been killed by a group of people around.
How many deceased have been? Pardon? How many people got killed?
There was charge. 17 persons have faced the charge.
No, how many got killed, sir?
One plus.
One person got killed.
Yes, plus. Banambar Pradhan is the deceased. And 1 person died. And was 28 persons were charged. You'll also can peruse page 52 of the paper book.
Yes.
It starts from yes, page 52. So it starts from. It starts 50 also. All 24 persons plus one is plus they have charged under section 149 of Indian Penal Code. Then 51 also will find that all are charged under 302 rated section 149 of the Indian Penal Code. Then on the next page, they all have been charged under section 148. You'll also get it from page 53.
Yes.
And also, as page 49, I beg your pardon, so I have not taken your lordships earlier. There are also 3 persons, they have been charged under section 302 simplicity. Page 49.
Yes.
Plus, and all have been acquitted. And PW 5 and 6 are the eyewitnesses. I am taking also to page 327.
Yes.
I know all the accused persons standing in the dock, and the deceased Banambar. Banambar was murdered before 1.5 years at about 9 p.m. At the time, I was returning from Delang Bazaar after selling the brinjals. I was coming on the canal embankment. Anand Behra was with me. This is PW 6 loss. Again says Anand Behra was coming 10 to 20 km ahead of me. We both of us were coming on cycle. While I was approaching the Godani, the slope that is usually we call Godani. In the village, Balegaon, I heard Halla, Marigali, Means I am dying. Anand Behra had a torch with him. When we both focused the torch, we found Banambar Pradhan was being assaulted by 15 to 20 persons by means of farsa, khonda, sword. He was being assisted by
assaulted
by the side of a small gadia. Gadia means pond, small pond. Banambar was raising Halla, Marigali, Marana, don't assault me, I am dying. When I raised protest, the accused Surya Mistri, identified, rushed towards me with a sword and threatened us not to interfere in the matter and to go in our own way. Otherwise, we will be cut into pieces. There I could identify the accused Naran Pradhan and Phagu Master, identified, who were the assailants. The above 2 persons were armed with farsas and were assaulting Banambar. When we were threatened by the accused Surya Mistri, out of fear, we ran from the spot. While we were coming, we could see the accused Godadas and Dharani Sahu, who were standing near the Kia bush, which is at a distance of 10 cubits from the place of assault. The witness says that the persons who were present at that place and were assaulting the deceased Banambar present in the dock. We came to our house. On the way, I found Naresh Bastia was sitting on his veranda, which I told about the incident. Cross plus. There is a Pakka road from Delanga Pipili. I am reading the whole statement so that you will also get the point. There is a Moram road which has taken start from Delang Pipili road up to Mangalpur. There is a cycle road from that Moram road to our village.
If one
would come from if one come from Delang to that Moram road, the distance would be 4 kilometers to our village. The distance between Delang and to my village on the way on which I was coming that day would be 5 kilometers and not 8 to 9 kilometers. From the spot when we went to our village, we crossed 2 villages. That means we passed through 2 villages. When we passed through the 2 villages, we have not told about the incident to any of the persons of those villages. Besides Naresh Bastia, I have told about the incident to other whom I saw, but I can't say their names. When I told the incident to Naresh Bastia, it was about 10 to 10:30 p.m. The place of assault is at a distance of 2 kilometers from my village. It took us 10 minutes to cover such distance. On the following day of the incident, at about 8 or 9 a.m., I was called by the police. Samal Babu, the OIC of Pipili PS, called me. I was examined by him and narrated the incident, what I had seen before him. I had also called Anand Behra with me. I was examined by the police first, then Anand Behra. He was sitting when I was examined by the police in the school. My statement was recorded in the presence of Anand Behra. I signed the statement recorded by the police. Anand also signed his statement recorded by the police. I don't know names of all accused persons, except 3 whose name I stated in the chief. Again, I'm reading, sorry. I don't know names of all the accused persons except 3 whose name I stated in the chief. Those persons who were congregated there and assaulted the deceased are all men of Baligan. I had stated before the IO that I don't know the names of the persons present there except those 3, but I can identify the persons If shown to me, I had not identified the accused persons either in a TI parade or before police, implicating them as the assailants of the deceased. While I myself and Anand were coming on our cycle on the way, I didn't meet any other person. When we first reached the place of assault, we found that the deceased was being assaulted inside the water ditch. The ditch in question was a muddy ditch and slush. I knew one number previously, his house from the place of assault would be 30 to 40 cubits. Just close to the canal near the place of assault, there is a sai called Girima Sai, consisting of 5 to 6 houses. Banam Pradhan was raising halla in top of his voice. I could hear the voice at a distance of 20 cubits while I was coming in a cycle. The place of assault is a dark place surrounded by kia bushes and other trees. We didn't raise halla, calling the attention of others. The place where we stood and saw the occurrence from there, if one would raise halla, that would be audible to villages Baliga and Girima and Orissa. In connection with this case, I have not gone to the house of Banam Pradhan to inform his parents. In the same night, I had told Naresh Bastia and some of his villagers, some of the villagers of mine, and had requested them to come to the spot for helping the injured, but none of them come. We have taken, we have not looked to the spot to know whether the spot was stained with blood. We saw the incident standing at a distance of 10 cubits to remain there for about 5 minutes. Naresh Bastia is an influential person of our village. The accused Godo and Dharani were standing near a kia bush. It's not a fact that I have not seen anything. It's not a fact that I have not come on the way I stayed in my chief on that day. It's not a fact that that was not the way which I usually come to my village from the Delang. It's not a fact that I am an arranged witness arranged by Naresh Bastia. Then paragraph 10, police was sent for me through Anand Behra, one who would sell the vegetables in Delang Station Bazaar. He had to obtain a receipt, but usually I don't, it is a little illegible on any receipt. I don't have any receipt. It is not a fact that my statement that I used to sell the vegetables in Delang Station Bazaar is not true. I am not a member of the cooperative society, nor I have not got any share. While Banambar was being assaulted, he had not uttered the names of any of the assailants or the names of the persons. I don't remember if I have heard that Banambar was saying, "Bhagya bhai mat marna marna, mu kali nisab kar di." I will decide it tomorrow. Don't assault me. It is not a fact that I have stated before the IO that I heard that somebody was shouting from inside the tag, "Bhagya bhai marigali mate marani, mu kali nisab kar di." Next part is very important. It is not a fact that I have stated before the IO that thereafter I got down from the cycle and saw the man who was shouting and washing was Banambar Pradhan. I have seen more than one person assaulted Banambar. The persons who had congregated there were not all assaulting Banambar. Some are assaulting and some are standing there. The persons who were assaulting the deceased Banambar were close to him. The rest of the persons surrounded the assailants and the deceased. We have not got down from the canal embankment to see the assault and the assailants. Anand Behra fast protested. We didn't utter name of any of the assailants when we protested. It's not a fact that I had stated before the IO that Fogu and Naran were assaulting with farsa specifically to Banambar Pradhan. Naresh Bastia is a rich man in our village, plus he has come today to the court. Myself and Anand have come to the court since yesterday. It's not a fact that I used to cultivate the land of Naresh Bastia. So, plus in the cross question, some questions have been put to him, and he has said that there is a congregation of people. Then was PW 6 is the other eyewitness. Start from page 333. Now, straight away I'm taking to Lordship to page 334, paragraph 2. When PW5 got down from the cycle, I've also got it. I've also got it.
334, no?
334, paragraph 2.
Yes, yes.
When PW5 got down from the cycle, we focused the torch. By focusing the torchlight, which was in my hand, I found just near the Godani. Godani means slope loss. Banamur was lying by the side of a dish where there was water. The accused Sriyapalli, Fogu Master, Fogu Behra, and Naran Pradhan, 4 names plus he has taken, he has sought out, were assaulting Banamur by means of swords and farsas. The accused Surya Mistri, his Suryapalli is otherwise known as Surya Mistri. Later he has stated. The accused Surya Mistri was holding the sword. The rest 3 accused persons were holding farsas.
there are other 20 to 25 persons there. When we raised protest, the accused Surya Mistry rushed towards us with a sword and threatened us, saying, slang language has been used, you go, otherwise we'll make you to two pieces. When we were coming back out of fear, we saw the accused Godadas and accused Dharanindas were standing by the side of Kia bush. Thereafter, we left the spot and came to our house on our cycle. The persons who are present in the congregation are present in the court. In the village, we reported the matter to Naresh Bastia. I am the co-villager of PW5. I am taking lawsuit paragraph 5 laws.
Yes.
The witness says Banambar was being assaulted inside that dish where water was there, where Banambar was lying, though it was bank of the dish, but there was water up to 6 inches deep. When we heard the halla, at that time we also heard the sounds of beating simultaneously. Hearing the halla, we could know that that was the voice of Banambar Pradhan. At that time, we also heard the halla of accused Surya Mistry when he threatened us. We have also heard ho halla, shout of many persons. When we were coming on the canal bond. Though I know Banambar Pradhan previously, but I was not well acquainted with him. I had also not talked with him. I have also heard Banambar told, Bhagya bhai maro nahi, mu kali nispati kari devi. Bhagya bhai, don't kill me. I'll decide the matter tomorrow. I have stated before the IO that I heard Banambar saying, Bhagya bhai marigali. It is not a fact that I have only stated before the IO that I had seen one person assaulted the deceased Banambar. The assailants were assaulting Banambar simultaneously. It is not a fact that I had stated before the IO that 20 to 25 persons of Banas village were assaulting him with Khonda and Farsa one after another. At the time of assault, many persons had surrounded Banambar. It is not a fact that I have not stated before the IO that when I saw Banambar was lying on the ground and he was being assaulted. Besides the persons who had congregated and surrounded Banambar, there I had seen any other person. As it was night, I could not mark. This was even I am taking a lordship to page 336. The focus of the plus top on the top line, the focus of the torchlight on the face of 2 to 4 persons we are facing towards canal embankment. The persons who are surrounded Banambar, some of them were facing towards canal embankment, the rest were facing towards the other direction. And the persons on whose face the torchlight was focused, they didn't rush towards us, nor they threatened us. It is not a fact that I have not said before the IO. I had seen Farsaj in the hands of Phogu Behra, Phogu Master and Narayan Pradhan. It is not a fact that I have not stated before the IO that we could hear the voice of someone crying in distress. Bhagya bhai marigali. I don't know. Phogu Behra maintains his livelihood. I don't know. These are all questions which are not relevant to the subject. And again, paragraph 8, you'll also find at page 337, they stated myself and people 5 are horizon by caste. And our house is in horizon side. Horizon is scheduled caste. There are scheduled caste people. Naresh Bastia is the man of Brahman side. It shows that they belong to scheduled caste community and they belong to Brahmin community. Both the Sai are the adjacent to each other. There are many families in Brahmin Sai, nearly 7 to 8 houses. We have not told about the incident to any persons of Brahmin Sai at any time. The place where we fast to Canal Bandha would be about 400 to 500 cubits. Plus, that is not that relevant. I am taking your lordship for a moment to the deposition of PW12 at page 353. Because prior to the incident, there was a meeting in the village and all the accused persons have assembled there. And this person was a witness to that and also is a post-occurrence witness. PW12. I know all the accused persons and the deceased Banambar. Banambar was murdered before 1.5 years. There are 2 groups in our village. Prior to the murder of Banambar, between 2 groups, OLR proceedings were pending. There was also gungo regarding the school between the 2 groups. One group was headed by Banambar Pradhan, the deceased. The other group was one was headed by the accused Jayakrishna Raut. The school gone was before 1.5 years of the murder of Banambar. Before 2 to 3 days of the murder of Banambar, there was a trouble between the two groups regarding the catching of fishes from the village tanks. There was also Gongor quarrel among those two groups when the accused Jayakrishna Raut misappropriated the Kotho money. On the day, Kotho money was common fund. Kotho money was common fund loss. On the same day, Banambar was killed. There was a meeting in the grocery shop of Vidyadhar Pradhan, accused, among the members of the group headed by the accused Jayakrishna Raut. Though I have not gone to attend that meeting, but I saw it at a little distance when I was going to attend the call of nature. I have seen in that meeting the accused Jayakrishna Raut, accused Vidyadhar Pradhan, accused Narayan Pradhan. That's all are named here in this case. At about 7 p.m., Manu Behera of our village told me that in the said meeting, the attending members were talking to murder the deceased Banambar Pradhan. He called me to go there to listen to their discussion. Both of us then went to the back side of the shop. We were standing at a distance of 20 kilometers from the place of meeting, concealing ourselves. We heard that the accused Bhagwan Pali and Surendra Pali were telling that they would obstruct the way when Banambar would return, and thereafter they would kill him. To my knowledge, I had seen that after taking day's meal, Banambar had gone somewhere out of his village on his motorcycle. When we had the obvious discussions in the meeting, we reported the matter to Gopal Behera of our village, who asked us to inform the matter to Banambar. We could not intimate Banambar as he was out of the village. At about 9 p.m., when I was going to sleep, I heard the sound of the motorcycle, and thereafter a holla of PW1, who raised holla. Bana Bapa Dodi Aso, Bana ko mari pokela. It's called Bana's father, come here, Bana is being assaulted. Hearing the holla, I came out of my house, ran towards the barrier of accused Jayakrishna Raut with a torchlight in my hand. When I was proceeding, I saw Phagu Behera, one of the accused Phagu Pali, accused Girdhari Pali, were running away towards Gahira. Gahira means land loss. By the side of the house of the Banapali. Again, I saw the accused Gandu Khati, accused Shankar Behera, accused Rabi Behera, accused Gatishwar Linka, Surendra Pali, Siddhi Pali were running away to different directions through the back of the house of the Braja Malik. Thereafter, myself and Manu Behera went and joined with PW3 and PW4. When we were searching after Banambar, we found his body was lying in the barrier of accused Jayakrishna Raut. When we proceeded towards the canal embankment, we found that the motorcycle and pair of chappal of Banambar were lying by the side of Mongolya Khatta. Khatta means one ditch. On 7th March 89 at about 1:20 p.m. at Pipli place, the OIC seized one lungi on production of Subhas Pali and prepared the seizure list. Exhibit 7 is the seizure list prepared by the police. He was also a seizure witness. And for a moment, I'll take a lordship to the injury sustained by the deceased. That is available at page 370, PW 18, sorry, 18. With the doctor who conducted autopsy. There is inside wounds 1, 2, 3, then 4. At serial number 4, it is multiple punctured wounds over the front of the chest and abdomens. Then also, at serial number 5, multiple punctured over back, 7 in number. And serial number 6, inside wound also there is, and also 7 inside wounds. 8 also there is and so many inside.
What does the trial court say?
Trial court disbelieved the version. I'm just taking it to us. And acquitted all the accused persons. I'm doing the relevant paragraphs. I start from paragraph 17, page 29. I'm starting with paragraph 16. It is undisputed position of law. It is undisputed position of law that the FIR in a case of murder is a very important piece of evidence. According to the prosecution, when the IO PW 23 went to the spot, PW 1, 3, and 4 were present. Admittedly, PW 3 and 4 are the parents of the deceased. It is not understood why PW 3 and 4, who are admittedly the parents of the deceased, didn't lodge the information. Rather, PW 1 was selected to be the informant. It is not out of place to indicate that it is the case of the defense that PW 3, the mother of the deceased, had lodged the FIR against the unknown person which has been suppressed, and the present FIR said to have been lodged by PW 1 is manufactured. According to the prosecution, the FIR now forthcoming marked as Exhibit 1 is lodged on 2389 at 11 p.m. at the spot. Undisputedly, it bears overwriting on all the places where the date has been mentioned. To the naked eye, it is clear that at first date 3389 were written, but subsequently corrected as 2389 in all the places. The carbon copy of the FIR produced in the court marked as Exhibit 1/4 shows the date as 2389 in all the places are intact and have not been corrected. The reasonable inference is that the above dates have been corrected subsequently in the original FIR produced in the court. Original FIR produced in the court. It goes without any dispute that FIR now produced in the court bears the signature of PW2 as a witness. PW2 in paragraph 3 of his evidence clearly says that he has signed the document on the following night. It is stated by PW3, the mother of the deceased, that she and her husband were taken in the next day evening, when for the first time they made the statement. PW4, the husband of PW3, father of the deceased, says in paragraph of his evidence that on the next Friday he was called, so also his wife, PW2 and PW1. His categorical version is that the statement of PW1 was recorded, and after recording her statement, the police took her LTI and PW2 also signed in that paper. This being the evidence, the inevitable conclusion is that the present FIR was lodged on the Friday, not during the night of occurrence. The delay of 24 hours in lodging the FIR in a case of murder is definitely fatal to the prosecution case. That apart, any sort of interpolation correction made in the FIR cast a serious reflection against the story of the prosecution. It is submitted that on the requisition of the IO, PW19, the scientific officer has visited the spot and had prepared a spot visit report, which is marked as Exhibit 14. It is categorically mentioned in the report marked as Exhibit 14 that some unknown criminals committed murder to Barambar on 2389 night at 9 p.m. It is stated by PW23, the IO, that all throughout he was present at the spot when the scientific officer remained there and prepared the report. It is not or unknown to him that in the report it was mentioned some unknown criminals committed murder of the deceased Barambar Pradhan. He denies to have drawn the state attention of PW19 regarding that part of the report where it has been mentioned that some unknown criminals committed murder of the deceased Barambar. It is admitted that a dog was taken to the spot to assist the IO in the investigation. PW20, Sri Niranjan Mahanti was in charge of the police dog, and on 3389 on the requisition of the OIC of Pipili PS, he had gone with the dog. It is evident from his evidence that a report was prepared at Pipili PS where he has given his signatures. Exhibit 16 is the report. There is a column in the report to mention the name and address of the complainant. Originally, the name of PW3 was made mention as a complainant, but subsequently it has been corrected as the name of Nishamani Beba, the wife of Bhikari Pradhan, PW4. Admittedly, Nishamani Beba is not the wife of Bhikari Pradhan, but of Kelu Malik. It is already indicated that one of the stand taken by the defense is that the original FIR lodged by PW3 against the unknown persons is suppressed, and the present FIR showing to have been lodged by PW1 is planted. If this report, Exhibit 16, where originally the name of PW3 was written as complainant, and if Exhibit 14, the spot visit report of the scientific officer, where it is mentioned that some unknown criminals committed murder, and when interpolations in the original FIR now produced in the court are taken into consideration together, the stand taken by the accused persons that some unknown culprits committed the murder of the deceased Barambar Pradhan, and finally the accused persons are roped with the case on account of previous enmity cannot be altogether ignored. There is another interesting feature which cannot be altogether ignored. It is evident from the evidence of the IO, that PW5 has stated before him that when the deceased was being assaulted, he had uttered the name of Bhaina saying, Bhagya bhai marigali mote marana, kali nispati karo. That is said that Bhagya bhai, don't assault me, I'll decide it tomorrow. So it is clear that while he was dying due to assault, he had only uttered the name of Bhagya bhai. And he is certainly not one of the accused persons. Because according to the prosecution, 4 persons, namely Surendra Pali, Naran Pradhan, Phagu Behera, and Phagu Pali were the real assailants. If the aforesaid 4 persons were the real assailants, then the deceased would have uttered the name of the assailants or any one of the name. But instead of uttering their names, he shouted, Bhagya bhai, marigali marana, which clearly shows that the real assailants was one Bhagya, who is not an accused. On this consideration, regard being had to the other circumstance, it is hazardous to believe that the above named 4 persons are the real assailants. It is stated by PW 21, the informant, PW 3 and 4, the parent for deceased, PW 12 and PW 21, that they had seen the accused persons were running away from the spot towards different directions. When it is stated by PW 1 that he saw the accused Jogia Lenka, Shankar Behera, Banko Behera, Gotishwar Lenka, Siria Pali, Bhagya Pali, Phagu Pali, Sindhu Pali, Naran Pali, all have name, and were running away from the spot. It is stated by PW 3 that he had seen that accused Bhaigo Lenka, Gandu Khoti, Shankar Behera, Rabi Behera were running away towards their house through the backside of Bhagavat Ghar. And when they further proceeded towards Mangudia Khato, she could see Godadas, Dharani Sahu, Subal Pali, Krishna Raut, Phagu Siari were running away towards the village Nuagodi near Basanti Thakurani. It is also stated by her that she saw Bhagya Pali, Siria Pali, Phagua Pali, Naran Pali, Giris Pali, Anam Swai, Narin Mani were running away from the barrier of Jogi Raut and went towards the villages through the barrier of Bhagya Naik and Binopali. She could see them as an electric bulb was burning in the barrier of Binopali and she was holding a torchlight in her hand. It is further stated that by her that she had seen the accused Jayakrishna Raut went inside his house. According to PW 4, while they were proceeding towards Mangula Khato, they saw Godadas, Dharani Sahu, Subhas Pali were running away towards the village Nuagudi. He doesn't say in his evidence that he had seen Krishna Raut, Phagu Siala were running away towards as stated by his wife. PW 3, as stated by PW 3, it is further stated by him that they saw Bhaigo Pali, Gandu Khoti, Jogi Lenka, Girdhari Pali, Naran Pradhan, Naran Pali, Anam Sahu were coming towards Gohira. Gohira means land by the side of the barrier of Binopali. According to PW 12, he saw the accused Phagu Behera, Phagu Pali, plus their name. Plus, the only question is, when after the assault, after killing that person, because there are so many persons there, 28 persons have been charged, or more than that even. They cannot go in a particular way. They have to go in different directions. So accordingly, the witnesses have stated that we have seen such and such persons. Another witness has stated that we have seen such and such persons. The court, learned court below has taken a view that no, everyone, suppose PW 3 and PW 4, they should state because they are the husband and wife. We have seen these persons going by this way. Because they have taken different names, that's why they are not believable. That part is not correct, plus, because they have committed a murder. And PW 5 and 6, they have seen the order, they have seen the occurrence. And in what way, plus, their evidence has been discarded on page 19.
19.
Only because he has not taken the name of Surendra Pali, Narana Pali, Phagu Behera, and Phagu Pali, who are the persons who are assaulting. Bhagya Bhai Manna, because they are not the Bhagya, he has not taken the name of Narana, Surendra, or Phagu or Phagu Pali. He has taken a different name, Bhagya. That is the reason PW 5 and 6 have been discarded. Even for a moment, plus the FIR will be thrown out. Suppose plus you will also not believe the FIR. But occurrence is true, and this is homicidal death, and also there is long-standing rivalry. There is motive very well present, and 2 witnesses who are witnessing the incident, PW 5 and PW 6, when they are categorically stating and taking the name of.
What is the date of this judgment? Trial court judgment. What is the date?
It was plus. It was plus 16th January 1991.
Wow. 51 years.
In the meantime, about 8 persons have died.
An incident of
Plus, that it took place.
89.
Yes, 89. 89. It took place on 3rd March 1989. So the reasonings, whatever has been given by the learned trial court, plus with due respect, are perverse. And here, so far as the concept of interfering in an order of acquittal, there are a series of judgments. Plus, I am showing one judgment of the Apex Court to your Lordship that is reported in 2007, Volume 4, SEC 415. Chandrapa and others versus State of Karnataka. Relying upon several judgments of the Honorable Apex Court delivered prior thereto, this judgment plus principles have been decided. That is paragraph 42. Your Lordship, will come to page 432. Including Shivaji Swara Babu's judgment also has been reported in that case, in this case. From the above decision, 432,
Yes.
page 432, paragraph 42.
Yes.
The principles have been summarized in this case. From the above decisions, in our considered view, the following general principles regarding powers of the appellate court while dealing with an appeal against an order of acquittal emerge. 1. An appellate court has full power to review, reappreciate, and reconsider the evidence upon which the order of acquittal is founded. Second, the Code of Criminal Procedure 1973 puts no limitation, restriction, or condition on exercise of such power, and an appellate court on the evidence before it may reach its own conclusion, both on questions of fact and of law. Various expressions such as substantial and compelling reasons, good and sufficient reasons, grounds, very strong circumstances, distorted conclusions, glaring mistakes, etc., are not intended to curtail extensive powers of an appellate court in an appeal against acquittal. Such phraseologies are more in the nature of flourishes of language to emphasize the reluctance of an appellate court to interfere with acquittal than curtail the power of the court to review the evidence and to come to its own conclusion. An appellate court, however, must bear in mind that in case of acquittal, there is double presumption in favor of the accused. Firstly, the presumption of innocence is available to him under the fundamental principle of criminal jurisprudence that every person shall be presumed to be innocent unless he is proved guilty by a competent court of law. Secondly, the accused having secured his acquittal, the presumption of his innocence is further reinforced, reaffirmed, and strengthened by the trial court. And if two reasonable conclusions are possible on the basis of the evidence and record, the appellate court should not disturb the finding of acquittal recorded by the trial court. Paragraph 43. Applying the above principles to the case on hand, we are of the considered view that the learned counsel for the accused is right in submitting that the High Court ought not to have disturbed an order of acquittal recorded by the trial court. For acquitting the accused and extending the benefit of doubt, the trial court observed that for the that case lost. So these are the principles, and you'll also find, if you'll also go through the judgments, you'll also find that judgment two forwards with due respect to the learned trial court was two forwards at several parts, and it has to be disturbed. With due judicial appreciation, my lords can disturb this judgment. Because, of course, this is now judgment of 1991. In the meantime, so many persons have died, and also about 30 years have elapsed in the meantime. And but still, judgment of this kind and taking such a view, and there are so many judgments I can show regarding admissible to the FIR and also the other aspect which has been dealt with by the learned trial court. come and they place their stand before lordship.
Clearly, they're not coming forward, sir. We've listed it for 4 days. Are you appearing for any of the accused here?
No.
Ah,
Waiting. No.
Nobody.
None is appearing. Last time also none appeared. And plus, I have given the instruction on the last occasion regarding the death of 8 persons. I have got it on 21st August 2022. Just 2 days back, 2-3 days back.
7, 1, 2, 3, 4, 5, 6, 7, 8. Correct. No. 7. 7 died.
7 persons. Sorry, Miss.
Orders reserved.
Supplementary list item number 62. Item 62.
Your Lordship?
Item number 62.
Yes, Your Lordship. Your Lordship, Mr. Panda is still on his legs in another court, Your Lordship. Can it be passed over?
You had asked for 2 o'clock. It's 2:45, sir, now.
He is in...
This is the Chief Justice's court. We expect some...
Indeed, Your Lordship, but he is in Justice R.K. Patnaik's court, Your Lordship, and the matter is going on right now, Your Lordship.
Yes, this is the next matter.
64 also his matter. Item 65.
65, Your Lordship. On behalf of Mr. Dhala, I pray kindly taken up next week, Your Lordship.
Why should we take it up next week, sir?
Well, the matter came in the supplemental list and yesterday at 9 o'clock, Lordship.
These are all date fixed, I thought. The date fixed matters. It's not suddenly in the supplementary list, sir.
Be specific adjoint to this.
It's specifically
Your Lordship, only I'm praying for next week any date, Your Lordship.
Sir, next week also you'll say the same thing, that it came in the supplementary list.
No, Lordship may fix it to 2
This is already adjourned, sir. This is already adjourned at request of Mr. Dhala, I think. What is this item 66?
65.
Monday, Your Lordship.
65.
65. Suppose we just put it all to the weekly list. We'll see come up high, no? Suppose we just shift it all to the weekly list. It will see come up high. Because you're all 2000, 2002, 2004.
Weekly list.
He's in Baylor. He's in.
Yeah, there are 2 appellants, Your Lordship. in criminal level 124 of 2005, Your Lordship. Out of them, the appellant number 1 is already dead, Your Lordship. And appellant number 2 is on bail.
He's on bail already, no?
Yes, appellant number 1 is dead and appellant number 2 is on bail, Your Lordship.
So actually the cost
After
title should
reviewing
now read Abhimanyu Patnaik.
Yes.
Abhi Patnaik is dead. You see the cost title of the present appeal will now read as Abhimanyu Patnaik versus State. Since the appellant number 1 is already expired. At the request of counsel for the appellant. Actually, you've already changed it to Abhimanyu Patnaik. Last order, only the cost list has not changed. You better change it in the cost list. Actually, this was at the request of Mr. Dale that we kept it today.
Lordship, I'm only praying for next week, Your Lordship.
Just say, don't take off that. The registry will ensure that the cause list correctly reflects the cost title of the case as Abhimanyu Patnaik versus Two, despite today's date having been fixed at the request of Mr. D.P. Dale, Senior Counsel, there is again a request for adjournment on his behalf. In the interest of justice, list on 8 September.
Supplementary list item number 66.
May I please? My lord, here the appeal is at the instance of the accused, my lord. He has been convicted for life imprisonment for commission of offense under section 302 of the IPC, my lord. Here, my lord, if your lordship will find, my lord, I confine my argument to 2 points only, my lord. That the trial court, my lord, relied upon the serologist opinion that the blood stains appearing in the lungi of the accused is tallying with the sari of the deceased, my lord, and both of are having the B group, my lord. First, my lord, first objection is the chemical examination report given by the doctor was not examined at all. And it was not subjected to cross-examination. Therefore, their report cannot be relied upon by the...
That is directly admissible. Chemical
number 2, my lord. That is my... My lord, number 2, my lord. My lord, in both your lordship, if your lordship will find from the report of the serologist, both the blood stain appear in lungi and sari is of B group, my lord. And the weapon of offense which was used in commission of the crime, it has also contained the blood stain, and that has not been examined, my lord, and not tallied with the my lord, blood stain with the
no, it's human blood stain anyway.
My lord, human blood stain, my lord. My submission is, my lord, so far as the blood stain is concerned, group B is concerned, my lord, 2 persons may be having same group of blood, my lord.
Okay.
So for determination, my lord, that point is there, my lord, for determination of whether that blood stain of the deceased or not, my lord, that has to be, they should have conducted the DNA test, my lord. Without that, my lord, the report cannot be accepted, my lord.
All right.
Number 2, my lord, your lordship may kindly turn to the spot map, my lord. Spot map of the occurrence.
Yes.
Page 69, my lord.
Yes.
My lord, your lordship will find that place of occurrence
is the, my lord, kitchen, and it is, my lord, just in front of the veranda, my lord. And on the next, in front of the, my lord, place of occurrence, there are house of, my lord, three persons. On the right of the occurrence house, my lord, there are persons, neighbors, but they were not been examined by the prosecution.
All right.
And your lordship will find from the FIR, my lord, the scribe said, my lord, the informant is an illiterate person, my lord.
Right.
My lord, your lordship, I would like to take your lordship PW5, my lord. PW5, my lord, the evidence of PW5, my lord. My lord, it is at page 48 of the paper book.
Right.
My lord, I know the informant Basanta Malik more than 1 year back. On a particular day, Basanta Malik, accompanied with another, approached me while I was running my cycle repairing shop near Bodh police station. However, on his approach, I wrote a report under the instruction of a person who accompanied Basant Malik. Then I read over and explained the contents to both of them. Then Basanta gave his signature, and also I gave my signature, exhibit 1/2 in my signature along with the endorsement. My lord, here, my lord, in the cross-examination, during the cross-examination, he has stated, I cannot name the person under whose instruction I scribed exhibit 1. My lord, informant to be the Basant Malik. And thereafter, what has happened, my lord? On asking Basanta, I ascertained that Thana Babu instructed him to get the report being written outside. In fact, the FIR was scribed for 2 to 3 times, and in each time it was shown to the Thana Babu. Finally, it was accepted by him. Actually, exhibit 1 was scribed in the night at about 8 p.m. As Basanta Malik was then crying, I read over and explained the contents of exhibit 1 only to the person under whose instruction the scribe was made. My lord, not the FIR was not scribed as per the instruction of the Basanta Malik. It was scribed as per the instruction of the person who accompanied the Basanta Malik. And he has also not been examined, my lord. And your lordship will find, my lord, in the FIR, it is in Bharlakula language, my lord. If, my lord, I will read out, my lord. Mu Sri Basant Malik, Pita Sukru Malik, Champapur, Thana, Bodh, ଆଜି 23/11/2003 ତାରିଖ ଦିନ ଥାନାରେ ହାଜର ହୋଇ ଲେଖି ଜଣାଇବା ରିପୋର୍ଟ ଏହିକି ଆଜି ଦିନ 3 ଘଣ୍ଟା ସମୟକୁ ଖାଇ ପିଇ ମୁଁ ଧାନ ଖଳାକୁ ଗଲି। ମୋର ସ୍ତ୍ରୀ କଳସ ମଲ୍ଲିକ ଘରେ ଖୁରୀ ଗିନା ଧୋଇବା ପାଇଁ ରହିଲା। ମୋର ଶାଳୀ ଅଷ୍ଟମୀ ମଲ୍ଲିକ ସ୍ୱାମୀ ଲୁନ୍ଦୁ ମଲ୍ଲିକ ଗ୍ରାମ ପଙ୍କୁଆଳ ଆମ ଧାନ ବୋହି ଆସିଥିଲା। ସେ ମଧ୍ୟ ଘରେ ଥିଲା। दिन प्राय 3:30 समय मोर भणजा आसी मोर शला को कहला अता मरीगला शीघ्र आस। मु शुणी घर को आसी देखिली मो स्त्री कलश तंटी कटा होइथिबारु से रक्ताक्त होई घरे मरी पड़ी। मोर शाली अष्टमी मल्लिक कहला भोला मल्लिक गोटे छुरी रे कलशर तंटी काटिदेला। फल मोर स्त्री भीषण रक्तस्राव हेतु घटनास्थल मरी पड़ा। मु घटना देखी कांदिबारे आमर धान बहुथिबा चंपेश्वर जानी लुटू मल्लिक अलेख अदर रघुमणि अदर और अन्य माने घटनास्थल आसी पहुंचीले। सेते बेलकु मुदला भोला मल्लिक उक्त घटना घटाई छुरी नहीं केउ आड़े पळाइथिला। माय लॉर्ड so far my lord, as per the FIR, my lord, Ashtami Malik, who was happens to be the eyewitness, he is the PW, my lord, 8. But he has turned hostile and he has said that he was not present at that time of occurrence. And so far as the other person who came from the spot and informed my lord, the informant Sali, who was present in the, informant Sola, who was present along with brother-in-law, who was present along with the informant in the threshing field, he has also not stated that he has rushed to and informed the, my lord, informant. So that is, my lord, that is why, my lord, in a case of circumstantial evidence, my lord, the chain which is required to be complete, it has not been completed. My lord, the motive behind the commission of crime, mens rea, is absolutely lacking, my lord. In this case, the informant himself stated that the Bhola Malik, the accused, has a good terms with the, my lord, family of this deceased and his husband, her husband. So, my lord, there is no conclusive proof, evidence available on record to indicate that the accused has committed the offense. My lord, the PW8, who is the star witness, as per the informant, that he has seen cutting the throat of the, my lord, his deceased wife. She has negatived the entire, my lord, statement of the informant, my lord. Your lordship may kindly peruse the statement of PW8.
Yes.
Page 54.
Yes.
Of the paper book, my lord.
Yes.
My lord, I'm reading out, my lord. I know the accused standing inside the door. Also, I know the informant and the deceased. About 1 year and 2 months back, on a particular day at about 3 p.m., when I had gone near to the tube well, situated at a distance of about 50 yards from our house, to clean utensils, the deceased was inside the house. After cleaning the utensils, when I returned back, I found that the deceased was lying dead inside the house, and she has sustained a severe cut injury in her neck. Immediately, I called Bikram to ascertain as to how the deceased sustained cut injury and died, my lord. So the statement of the, my lord, PW8 is completely contrary to the statement of the, my lord, PW1, my lord.
It's turned hostile. They've been declared hostile.
My lord, she has been declared hostile, my lord. And in the cross-examination also, my lord, the prosecution could not elicit any, my lord, iota of evidence or statement which relates to the commission of offense by the, my lord, accused, my lord, the appellant, my lord. And the my lord, PW10, who happens to be the nephew, he has deposed in the court, my lord. He has never disclosed this fact to anyone else except the police. But the informant stated that the nephew came to the threshing field and informed the brother-in-law of his brother-in-law. So there is no connection, my lord. And the scribe who says that it has been scribed at the instance of another person.
You're now repeating yourself.
My lord, my lord, just I am trying to, my lord, convince your lordship, my lord, that the occurrence happened. It is no doubt, it has happened. But it has been, my lord, the entire story has been created at the behest of the, my lord, informant to accuse one particular person at his behest. My lord, so far as the leading to discovery is concerned, my lord, the knife was which was used in the, my lord, in the commission of crime is found in an open space, accessible to all, my lord, anybody, my lord. So that is why, my lord, that portion cannot be, my lord, leading to discovery also cannot be relied on, could not have been relied upon by the trial court, my lord.
All right.
And so far as the, my lord, I am again, my lord, at the cost of repetition, my lord, that the blood stain that has to be, cannot be stated to be the conclusive evidence, my lord. Because, my lord, in absence of, my lord,
it is conclusive evidence, please. It's only a corroboration.
My lord, one thing, my lord, the serologist who gave the report has not been examined.
Anyway.
Number two, my lord, the neighbors who were immediate neighbors are present in the spot of occurrence, but they were not examined. So, non-examination of serologist is fatal to the case, my lord.
All right. Yes, Mr.
Malas. I just want to draw lordship's attention to page 61.
Yes.
The deposition of PW 10 plus.
Yes.
Even though PW 8 has turned hostile, PW 10's evidence is very much important. Yes. I know the accused standing inside the dock. Also, I know the deceased Kolos and her husband Basant Malik. About 1 year and 3 months back on a particular Sunday at about 4 p.m., when I had sat on the outer veranda of Kolos Malik, after taking my lunch in the nick of moment, Hostile Malik, PW8 was turned hostile, of course, raised halla to the effect. Dauda Bhola Malik Katidala. Because he caught the neck of the deceased, that is why he told that she was informed that Dauda run. Hearing the said holla, I rushed inside the house and found that Bhola was holding, the accused was there, was holding a knife, and there was a stain of blood on the knife and wearing clothes of the accused. I also found that Kolas Malik, having a bleeding injury at her neck, was lying inside the house near her kitchen. So the accused was there inside the house of the deceased, and there was accused was near the deceased. His presence is very much proved. And deceased was having the injuries on her person, which was well corroborated by the doctor, and stains of blood have been found in the chemical exams report, that is of group B, which has not been explained. Rather, a false plea of alibi has been taken by the accused. And grouping also, the blood group is matching both the wearing, that is apparently visible on both the wearing apparel of both the accused and the deceased. So even if he has no probable, Taylor has not seen the exact assault, but he has seen the accused being present near the deceased who was lying on the ground inside his inside our house, and what more is required, my learned friend is saying. And it is admissible, chemical exam report is admissible evidence, directly admissible in evidence. It's not required to examine the chemical examiner.
What do you say about that? No independent, none of the other neighbors were examined? The close neighbors of.
But that has been exhibited.
No, the spot map shows there are many other houses. So he's saying, how come you did not examine any of them?
No, so the PW, the husband has been examined as PW. Basant Malik has been examined as PW1.
Neighbors.
No, never husband.
My lord is asking about neighbors.
Spot map. If you see the spot map, there are many houses around the house where the occurrence happened.
So the sister-in-law has been turned hostile. Probably finding that the PP might have understood that they may turn hostile. That is the reason they might not have been examined. Because it is the discretion of the PP to examine who should be examined, who should not be examined. Because before examining a witness, before putting a witness to the dock, usually the PP usually decides actually whether he will be hostile to the prosecution or not. Maybe that is the reason why all might not have.
Then he says serological report, there's no human blood, only human blood on the knife, and
blood is there.
Blood group is not there.
Grouping is not there, but human blood is available. That is even enough.
Then he says, by coincidence, both could have same blood, accused and deceased. He says you should do DNA. He's saying that you should have done a DNA. It's not enough to match the blood group of the accused and the deceased, the dresses of the accused.
No, even that is an incriminating circumstance. The very presence of blood on the weapon of offense is saying that there is no weapon of offense. Weapon of offense carries the blood, but grouping is not there. Grouping could be made possible because a sufficient amount of blood must have been there. That is the reason why chemical examiner could have made the grouping. Here, that blood must not have been to that extent to examine the grouping of that blood. But blood is there available on the weapon of offense, and that weapon of offense has been seized. And that the opinion of the doctor that this is the weapon which has shown to me, and he has opined that the injuries are caused by this weapon.
Weapon of offense is from an open ground. It could have easily been planted.
And one more thing, my lord. Nobody has identified that lungi belongs to the accused, my lord.
I will provide a recent judgment of the Honorable Appeals Court. Just now I have not got it. Regarding if a weapon of offense is available in open space, it is open, accessible to the public. Even in that case also, that benefit cannot go to the accused. And here the person was very much available. He was seen there inside the house of the deceased. And deceased was lying dead. He was standing with a weapon. And who else can cause the crime loss?
What is the motive, sir? He says no motive.
Motive plus, and to some extent it has come up because if accused happens to be a relation of the deceased. No, so I'm just coming to PW1's evidence.
Accused. No, deceased relation of the husband, sister happens to be the sister and married.
Yes,
She has
he
been
was
taken
earlier
up,
married. She was
kidnapped
earlier
and
married. So then she was kidnapped by the
husband
husband.
and married.
So that said, of course,
there was a strained relationship
That I'm
between the
reading.
husband and wife, my lord.
And they were staying at husband and wife.
And
But she was
that
kidnapped
lady
by,
belonged to the
PW1
caste, my lord.
So that is the reason which was was being protested by the accused ultimately because she was related. Well, I'm coming to that.
And the PW10 is related to, my lord, the deceased husband, informant. And she has stated everything before the court, not prior to that.
And leading to discovery has been proved by PW3 loss.
Para 5 of the cross-examination.
Page 42, I'm reading that paragraph 3. Then the accused led the police party in my presence to the place of concealment and gave recovery of the open of offense. The knife which was seized by the police babu who prepared the seizure list. Exhibit 5 is the said seizure list and exhibit 5/1 is my signature. It is the statement of PW3. It is available at page 41.
My lord, it is also contradictory because of, my lord, police says that it has been seized on 27/11 and the witness says that 4th day, my lord, on 28/11, my lord.
Yes.
I'm sorry, I'm good.
And my lord, so far as the cross-examination of PW1 is concerned, my lord, in para 5/6, he has stated that there are some differences with the wife and she was kidnapped and she was trained to, my lord, Kalsi, my lord, that one type of, my lord, she was doing mesmerizing work in the village, my lord. She has stated. He has stated in para 5, my lord.
Yes.
My lord, para 6, during light time, Koloso was doing Attari Puja. At the time of Kartika Dasami, every year Koloso was doing puja with pomp and ceremony, inviting spiritual Ottakasi, god and goddess, Chandi, Chamundi, etc. It is not a fact that, my lord, my practicing black magic, Koloso was doing positive harm to many villagers, even caused death to some of them, and caused disturbances in the matrimonial relationship of many villagers. So that for the reason, my lord, to the best of my knowledge, accused was pulling on well with the deceased, my lord.
It is to his best of his knowledge. But accused was pulling not pulling on well, and why the accused killed the deceased?
Sir, that is the prosecution failed to prove the motive behind the commission of crime.
10 is as good as an eyewitness. He has seen the accused standing there inside the house of the deceased and with the weapon of offense in his hand, and which was bloodstained. That particular aspect, that particular circumstance is to be answered by the accused. He has not answered it in his statement, record admission 313. Rather than what he has stated at page 34 of paper book.
Only false implication.
Motte Morei Dhamki police micho case karichi. Putting me under threat, police has initiated false case against me. And a specific question has been put at
page 32, question number 2, it further transpires from the evidence of PW10 that after hearing the said Halla, when he rushed inside the house, he found that you were holding a knife, having stains of blood, and your wearing clothes were also stained with blood, and the deceased correspondingly having a bleeding injury at her neck, was lying inside her house near the kitchen room. What have you got to say? He said false.
False.
Everything he has stated false. Yes. And one question number 4, it further transfers from the evidence of PW3 and PW9 that while you were in police custody, you gave information in presence of witness regarding concealment of the weapon of offense, the knife, which was reduced into writing by the IO, PW9, and you led the police party to the place of concealment and recovery, gave recovery of the weapon offense, MO1, which was seized by the IO under seizure list, Exhibit 5. What have you got to say? He has answered, police ro dhamako pittiwaku mariyaku kohiaru mu se kamo kariu raji heli, se churi police poti thila. Police has planted knife under that because because coming under the threat of the police, I said all these things. And regarding that chemical examination report, question number 9, it further transfers from the chemical examination report at Exhibit 13 that traces of human blood pertaining to Group B was detected in your check lungi, MO3 and red colored sari of the deceased, and also human blood was detected on the seized knife, MO1. What have you got to say? Michakota. This is false. So he has not answered because these are all incriminating materials against the accused.
Yes.
A small written note of submission was just I'm giving, and I'll provide the list of citations.
All right. You can also give us a note of submissions.
Well,
all right. Orders reserved. Written note of submissions if any be filed within 1 week.
All right.
I'll provide a list of citations.
All right. All right.
Item 69 now. Mr. Jaffar.
The appellant is convicted under section 302 and 307 IPC, and he was charged under section 302 by 307 IPC and sentenced to life imprisonment. And the informant here, is prosecution case is the informant is one Ramchandra Meher, who has been examined as PW2. The informant has been examined as PW2 and is the brother of the deceased.
Yes.
Of course, he is not an eyewitness to the occurrence.
Right.
And the entire case rests on the evidence of PW 5, 6, 7, 5, 7, and 9. 5, 7, and 9 who are the eyewitness to the occurrence, out of which PW 7 is the injured eyewitness to the occurrence. Before I will addressing the entire case. This PW 7 but the basis of the case that entire prosecution case, if you also will see in the FIR, the present appellant is the only accused named in the FIR. There is no story, the prosecution case that injured and the deceased, injured PW 7 and deceased, while both were standing, there was a altercation with the appellant. Thereafter, it is alleged that appellant gave a knife blow to the deceased as well as to the injured. And here the entire prosecution case is the accused, the appellant is the only sole accused. But subsequently during course of trial, this PW 7, he made a complaint petition. When even he made a complaint petition bearing in the year 2006, its occurrence took place in the year 2000,
occurrence took place, my lord, in the year 2006, and immediately, my lord, thereafter, during course of trial, this complaint petition was another a complaint petition in the same year. He has filed a complaint petition by the injured PW7, and my lord, arraigned my lord, the entire family members, including the accused, this appellant, and it's a different story. And the allegation that the appellant, his brother and father, all have assaulted, and Lord Magistrate, my lord, also took cognizance. His father was arrested, and some of the case was committed to the Court of Sessions. It was not brought to the knowledge of the court that both the cases to be, my lord, tagged, my lord, together. Instead of doing, my lord, this case tried, my lord, and your lordship, I have the copy of the complaint petition, including the deposition, if your lordship. I don't know what is the further evidence, but the evidence was collected and a new story was developed that the present appellant and brother and father all have assaulted, my lord. Only, my lord, I think to cope the prosecution case. If your lordship and the copy. This is the mallet. I'm giving the mallet, supplying the certified copy of that order, and including the deposition of another this eyewitness. Lordship, can have a yeah.
Yes. No, we have the depositions here.
No. This is a separate case, my lord. When a complaint, the injured, my lord, who was deposed, a new case was introduced by the PW7 by filing a complaint petition. And in the complaint petition, because, my lord, my case is that I will address the court, my lord, regarding my case. But before that, I want to know your lordships, my lord, to know that this case, the PW7 is the only, my lord, important witness who is an injured eyewitness to the occurrence. And another witness who has also been cited as a witness in this case, in the complaint petition. What happened, my lord, FIR was registered against this present appellant only. Case was arrested, he was arrested while he is in custody, my lord. Another complaint petition was filed, and a new story was developed that not only this appellant was also made an accused. Apart from that, his father, brother, and other family members. Kindly have a glance to the complaint petition, and this complaint petition was filed by the injured, on the basis of which the conviction has been held, my lord.
All right.
So he made a new story, my lord. He made a new story and is saying that this appellant and father and brother, they have assaulted. So I want to appreciate your lordship that the evidence of PW7, however, can be accepted when he is changing a new story.
All right.
So that is why I am supplying the copy of the certified copy of the order and also the evidence. Case was committed and trial was commenced, and the evidence, one of the witness also examined and he deposed. And deposed regarding the complicity of the appellant as well as this Bijay, my lord, the complainant Bijay Sahu, he is the injured eyewitness. He is the injured eyewitness.
What is the result of this case, please?
He is the complainant and he accused the appellant as well as other accused persons. I learned trial court.
No, what happened in this case?
Is evidence I have given the one of the copy. Thereafter, my lord, case was did not further proceed because he is in custody and his father was dead. What I got instruction.
So it's not completed yet.
So no.
So why should we rely on something that is not yet complete?
No, complete, my lord.
Unless the trial is concluded, we can't rely on these.
Your lordship, that is why I am, my lord, praying. Your lordship should call for the report. This secret.
No. This is something that we should not even look into, please. This is still being appreciated by a trial court. We don't know what the outcome of that trial proceedings will be.
No, when the evidence is giving a separate evidence, that is why.
We may use something in that case. No. Something which is not complete there, we cannot use it here, please. I'm finding this argument very strange. That trial is not complete, no judgment has been delivered. So it's incomplete. Those proceedings are incomplete. We can't even rely on it here.
No, I'm placing that copy only in order to appreciate lordship that the evidence he is making a separate.
See, we can't even use it. In this case, we can't even confront these people with what they're saying there. It should be the other way around. There you can confront him with what he has said here.
No, that is such a, that I will.
That is the only thing. That is the only thing you can do. You can't make us appreciate something which is deposing, which is still not even looked at by the trial court. No opinion has been formed thereon. Nothing.
I'll place the entire case. Thereafter, I will submit regarding that evidence.
Just give it back.
Yes. So, my lord, the prosecution case is that the informant who is the PW2. Informant PW2 is the brother of the deceased and he lost the affair. He is not an eyewitness to the occurrence and may place the evidence of PW2 first, the evidence of the informant. Deceased Dhanpati was my brother. I am the informant in this case. I know the accused Prahlad's house standing in the dock. The alleged incident took place on 4/5/2006 at about 9:30 p.m. to 9:30 to 10 p.m. in night. At the aforesaid time, I was present in my house and was waiting for the deceased brother to take our dinner. As for a long time, Dhanpati did not return home. I went to search for him and in the middle of the basti, I heard that there was gandogol between Dhanpati and Prahlad Sahu at Khuntiapada. And Prahlad Sahu assaulted my brother Dhanpati by a knife and my brother was hospitalized. On getting this information, I went to Binka hospital and saw my brother was lying unconscious and he had sustained bleeding injury on his right side belly and left elbow joint. At that time, one Vijay Sahu of Khuntiapada had also sustained injury on his person and was undergoing treatment at Binka hospital by the side of the road, side of the bed of my brother. And on my query, said Vijay told me that accused Prahlad has stabbed him and my brother Dhanpati by knife. After some time, my elder brother Dhanpati succumbed to the injuries and as the condition of the Vijay was serious, he was referred to VSS Burla for treatment. Thereafter, I reported the matter to Binka PS. This is my report under Exhibit 1 and Exhibit 1 by is my signature. On the next day of the report, police came and held inquest over the dead body of Dhanpati in my presence and prepared inquest report. I have sent. So this informant, he is getting information from Vijay Sahu. He is not an eyewitness to the occurrence. He is not an eyewitness to the occurrence. He heard from injured PW7 from Vijay and he lost the affair. Now, your lordship, PW1 is the uncle of the deceased and of course he is a post-occurrence witness. He turned hostile. He is not a. Thereafter, PW3, he is also a post-occurrence witness and heard about the occurrence and he is also turned hostile. Then PW4 is a seizure witness. Now, PW5 is an important. 3 witnesses. PW5 is one of the relevant witness. He is an eyewitness to the occurrence. He is the mother of the injured.
Yes.
I know the deceased Dhanpati, running page 48 of the paper book.
Yes.
I know the deceased Dhanpati. Injured Vijay is my son. I also know accused Prahlad Sahu standing on the dock. The alleged incident took place about 1 year, one day at about 9:30 to 10 p.m. at night. At that time, I was present in front of my house. And at that time, Dhanpati and Vijay returned after distributing a marriage card of my son. And while they were present in front of our house, I heard that the accused was making hue and cry near the house holding a knife. When seeing this, Dhanpati protested accused Prahlad. Prahlad chased him holding the knife and stabbed on his belly by that knife. When seeing this, my son Vijay rushed to the intervene. Prahlad also assaulted him by knife on his belly side and left side west. Due to assault, Dhanpati ran away and my son Vijay fell down at the spot. So we shifted our injured son to our house, and thereafter Jitin Pancha, my husband and myself took injured Vijay to hospital for treatment. Dhanpati was taken to hospital for treatment where he died. Thereafter he shifted. Then in the cross-examination, house of the Prahlad is in front of our house on the other side of the road. I cannot say the breadth of the road prior to the incident, and we had no enmity and ill feeling with Prahlad and his family members. I have been examined by the IO in connection with this case. It is a fact that I have stated before the police that I was present in front of my room of our house. It is not a fact that I have stated before the police that first Prahlad stabbed on the belly side of my son by knife and thereafter stabbed Dhanpati by knife. Lakshmi Sahu is the sister-in-law of the accused Prahlad. I do not know if Lakshmi Sahu has filed complaint case against my husband and son bearing 1cc case number so and so in the court of the SDGM Sonpur, alleging that my husband's sons had abused and assaulted them and had damaged the tiles of the roof of their house. I was sitting with my husband and daughter in front of house since 5:30 to 6 p.m. and was waiting for my son, who had gone to distribute marriage card, who had gone to distribute marriage card to take our dinner. No other outsider was present at the spot at the time. My husband and my daughter were also present at the time of occurrence. My son Pancho was absent in the house. So, except this, he's saying, except this, no other outsider was present, because I will cite another witness. I will comment regarding. No outsider was present at this spot at the time. My husband and my daughter were also present at the time of occurrence. My son was also absent. My other two sons had gone to Ulunda, where we had got a jewelry shop. Accused Prahlad had dealt 2 knife blows to the belly and chest of Dhanpati, and Prahlad had dealt 1 blow to my son Vijay. Dhanpati went to hospital by running. It is not a fact that Prahlad has not assaulted my son Vijay and Dhanpati by knife. And there I am the mother of the Vijay and deposing falsely. My lord, now the another eyewitness.
What is wrong with this witness?
Wrong, my lord, I will comment, my lord. This witness has stated that this appellant has given only 1 blow. First, he's given a blow, and then in cross-examination, she is saying that only 2 blows he has given. Thereafter, my lord, he fled away to the deceased run away to the hospital, and he has given in the chief examination, chief, my lord, she stated that Dhanpati, specifically she stated that Prahlad chased him holding knife and stabbed on his belly by that knife. When seeing this, my son Vijay rushed to intervene. Prahlad also assaulted him by knife on his left side belly and left side waist. Due to assault, Dhanpati ran away. So he has given, my lord, he's saying that he has given only single blow to the deceased.
What does it matter, sir? What does it matter?
Because he has sustained 5
knife blow. What more do you need the witness to say?
Because
witness should fully sit and calculate number of blows.
No, number of blows. He is
anyway, whatever she failed to say, you elicited from her twice in the cross-examination. So you made sure that she properly recollects. In the cross-examination, you have given her opportunity to explain that he got 2 blows.
He has sustained, but from post-mortem reports, he sustained 5 blows, 5 injuries.
So this is to your advantage, according to you.
He has taken.
This is to your advantage. The man has died. So whether the witness said he was stabbed twice or 5 times, according to you, because he got more injuries than she says, he should be acquitted.
He sustained as per the evidence of PW5. He sustained only in the chief. He is saying that only he's given one blow. After sustaining one injury on the specifically, he is saying that he's given one blow on the belly. Thereafter, he will run towards my lord the hospital. Now the evidence of PW7, my lord.
Yes.
PW7 is the injured. He is saying that I know the accused Prahlad Sahu standing in the dock. I know informant Ramnaran Meher and deceased Dhanpati Meher. The alleged incident took place on 5/5/2006 at about 10 p.m. at night. At the aforesaid time, myself and Dhanpati, after distributing my marriage invitation card and in front of our house, I saw accused Prahlad was raising hue and cry and was abusing in obscene language. So Dhanpati asked Prahlad as to why he was abusing him in obscene language. At this, Prahlad got annoyed and stabbed on the left side belly of Dhanpati by a knife. And when I intervened to rescue Dhanpati, Prahlad stabbed on my right side chest by that knife. Due to stabbing by knife, myself and Dhanpati sustained bleeding injury. Prahlad dealt another blow on my back, as a result of which I fell down on the ground. Thereafter, Prahlad chased Dhanpati and again assaulted by him by knife. Hearing my halla, my brother rushed to the spot, and so Prahlad fled away from the spot. Thereafter, my brother shifted me to Binka Hospital for treatment. From Binka Hospital, I was referred to VSH Medical Burla for treatment. I was treated at Burla Hospital as an indoor patient for 15 days. While undergoing treatment at Binka Hospital, injured Dhanpati expired. Prahlad's house is in front of our house. Prior to the date of occurrence, there was no gandogol or dispute between myself and Prahlad or between our families regarding any matter. My parents and brothers were present in front of our house, and the family members of our Prahlad were present in front of the house when the incident started. Dhanpati has sustained injury on the belly and 2 injuries on his left elbow joint.
All right, we'll stop here. We'll continue next week.